I may be permitted to mention number 7 cases, my lord, 7 first appeals, which are fixed on 20th of this month, my lord. In all these cases, substitution petitions are pending, my lord. So they may.
आपको इन्होंने मना किया मेंशन स्लिप लेने से, और 7 केसेस है तो 7 मेंशन स्लिप्स होने चाहिए. एक मेंशन स्लिप से 7 केस.
I am giving the list of cases.
हाँ? नॉट लिस्ट नहीं, आपको सबका अलग से मेंशन स्लिप देना पड़ेगा बना.
Actually,
उसमें भी आपको परेशानी है.
these are only the list.
ऐसे होता है, मेंशनिंग रिकॉर्ड में मेंशन स्लिप लगता है तब मेंशन अलाउ होता है.
My lord, second case for hearing. First appeal 175. I was praying for time, my lord.
Rejected. हाँ बताइए.
Serial number 18 under the heading order 41 rule. सवा दो बजे खाली सवा दो बजे के लिए प्रेयर कर रहे हैं. सवा दो.
Order serial number 45. First appeal.
आप लोग को सबको मना किए ना, प्लीज मेंशन मत किया करिए. बैठने के बाद 5-7 मिनट क्यों आपको मेंशन करते हैं? आपको एडजर्नमेंट चाहिए?
नहीं, एडजर्नमेंट
विड्रॉ करना चाहते हैं?
नहीं.
हाँ तो बस कुछ मत करिए.
एक डेट फिक्स करने.
डेट आज ही के लिए फिक्स्ड है. 4 दिन. जी डेट आज ही के लिए फिक्स्ड है.
From the supplementary list
नेक्स्ट वीक के लिए.
under heading for order
आज नहीं होगा तो नेक्स्ट
item
वीक
2
अपने से आएगा.
SF 47 of 2024.
Yes.
Two defects that are existing. One is of the limitation that is in serial number 2, and in all other cases, the defect is with respect to filing of certified copy.
No, just a moment. Let's see one by one. You have filed your limitation petition. Then what else? Court fees
Court fees
has been filed. So there is no other defect in the first matter.
in the first one.
Then I'll issue notice. There are other similar matters?
Yes. The other matters are there.
Just a moment. So far as the first case is concerned, do you want these matters to be fixed on a particular date? What is that date? Because are there any other matter fixed on any particular date arising out of the same award?
All these matters were earlier pending for removal of defects via preemptory order.
Are there other first appeals similar first appeals? You have no idea.
The dates have not. So this is the first batch, the first cases of the batch that are coming.
Where is the rest of the cases? Where is the number of rest of the cases?
I will give the number.
You come with that.
There are 16 cases in today's list.
Okay, how many cases are there? Yes?
I will give the example.
Please don't waste our time in the morning, okay? When there are batch of matters, you should be ready with all this. Go and get this data. Come at 12 o'clock. You just get these data, get the case numbers, and we find out what is the stage of the case. You may also find it out.
Under heading for hearing under order 41 rule 11 of CPC, item 19 SA 63 of 2021.
अच्छा ये सवा दो मेंशन करते हैं ठीक.
Item 19.
Where is the appellant? कोई किसी का responding का clearance है? Where is the appellant? विजय कुमार शर्मा का नाम पेश करें। नहीं आते हैं तो केस डिस्कस करना है। बिना सब्सटैंशियल क्वेश्चन ऑफ लॉ बना के इशू नोटिस हुआ है इसमें।
Under heading for hearing, item 20, second appeal 88 of 2019.
सारा पास ओवर केस 12 बजे फॉलो होता है, ठीक है? पास ओवर।
From the daily list, under heading for to be mentioned, item 1, WPC 3092 of 2022.
There is some error in the order. क्या error है?
लेकिन उसमें जो डेट ऑफ ईयर है वो 23 के जगह डेट ऑफ ईयर जो है सारा
Year of the
डिफरेंस
case is WPS 3092. WPS number 3092 of 2020. This matter has been placed at the instance of the office, indicating that the case number WPS 3093 of 2023 in paragraph 3, 4, 5, 6 and 7 of order dated 31/1/2025 has been wrongly typed, and the correct case number is WPS number 3093 of 2020. Peruse the order and considering the office note, the order dated, there appears to be typographical error in the order dated 31/1/2024. Accordingly, order dated 31/1/2025 is hereby modified, and the case number WPS number 3093 of 2023 appearing in paragraph 3, 4, 5, 6 and 7 is hereby modified and is directed to be read as WPS number 3093 of 2024. Office is directed to carry out necessary corrections in the order dated 31st of January 2024.
under heading for final disposal, item 2, first appeal 175 of 2024.
ready for time. I have not received instruction, my lord. Firstly, secondly, some proper compromise is going on. And my lord, my client will be coming next week, and they are to execute the lease deed with ICICI Bank.
It's the first appeal.
My lord, so let it be adjourned.
Adjournment is not your right.
My lord, I know it's not my right. I am making a prayer only.
We have read the plea. The records are here.
My lord, I have not received instructions from me. My clients are out of India. They will be coming next week. They have to execute the lease deed in favor. There's some compromise is also going on.
Compromise is
No.
gone.
Oh.
No.
ठीक है, but they have to execute the lease deed in favor of the ICICI.
So how does that make a difference?
My lord, that will be very relevant because,
No.
my lord, then I have not received the instruction also.
Then don't press it, we'll dismiss it.
My lord,
You have filed your wakalatnama in 2024. This is a case of
my lord,
2024.
my
And you say you have not received instructions.
my lord, my wakalatnama is not there.
So whose wakalatnama is there?
My
I
lord-
dismiss it, you have no instructions.
My
Don't
lord,
advocate, please.
my lord,
No.
if it is adjourned to next month, first week, how the heaven is going to fall, my lord?
Heaven is going to fall, no? Because I have spent 1 hour reading this file.
My lord, it may be kept as battered, then it will be.
Dude, I can't read a matter parted unless I hear it parted. Right? I cannot simply say it's a parted matter. You place the impugnment. You place the written.
I'm not ready.
There is no perversity in this judgment, my lord, rendered by.
No, first appeal, we have to see everything, no? We
Yes.
have to see the plaint, the written
Yes.
statement, the evidences, the point of determination, everything has to be seen.
Yes.
You can't say there is no perversity. Second appeal थोड़ी है. First appeal का पूरा record पढ़ना होता है.
Yes.
ऐसे थोड़ी होता है first appeal. There is a procedure of determining first appeal. You have got your records.
My lord,
You also don't have your records.
no, they have not served me the memo of appeal, but I have
But
got
we
the
had served, my lord, we had sent notice about
notices. I have only
कोई
served.
बात नहीं. मेमो ऑफ अपील में कोई भी ग्राउंड उससे कोई फर्क नहीं
फर्क
पड़ता
नहीं
है.
पड़ता है.
सेकंड फर्स्ट अपील है.
I have received all the documents from
They
my
have got
client
all the-
yesterday itself.
क्या करेंगे बताइए?
हम तो अब रेडी भी नहीं
बिना
हैं।
कॉस्ट के हम एडजर्न नहीं करेंगे.
हम क्या बोल सकते हैं, हम तो
कोई
cost
नहीं
लगा के
बोलता.
adjourn कर
आपके क्लाइंट को देना है उससे क्या ही फर्क
नहीं
पड़ेगा?
नहीं कॉस्ट लगा के एडवांस कर दीजिए हम।
कॉस्ट लगा के adjourn कर देते. कब चाहिए आपको? नेक्स्ट वीक.
नहीं नेक्स्ट वीक आई एम गोइंग फॉर कुंभ माय लॉर्ड, आई वोंट बी हियर। तो हम बोल रहे थे नेक्स्ट मंथ रख दिया जाए।
अभी तो आप नेक्स्ट वीक बोले थे.
नहीं नेक्स्ट
लेकिन
वीक
नेक्स्ट मंथ बोलेंगे तो आप रख देंगे. कोई नहीं.
हम नेक्स्ट मंथ ही बोले थे क्योंकि हम कल अगला वीक तो कुंभ जा रहे हैं, वहां से आएंगे, उसके बाद माय क्लाइंट विल बी कमिंग नेक्स्ट वीक, दैट इज व्हाट आई
तो
सेड।
कल जब वो आएंगे तब आपसे तो मुलाकात नहीं होगी.
हाँ
आपसे तो
ठीक है,
मुलाकात
वो तो
नहीं.
आएंगे तो उनको तो एग्जीक्यूट करना है, पहले डिस्ट्रीट दोनों को डिस्ट्रीट करना है बैंक के साथ, उसके बाद हम तो आ ही जाएंगे नेक्स्ट वीक के एंड तक, वो भी वीकेंड ही तक आ रहे हैं।
देखिए एफए नंबर 175 और 2024. Mr. Pradeep Modi, advocate, submits that he is not ready in the matter. However, he submits that. No, he has also submitted that he is not the advocate on record, but he is seeking instruction, he is seeking adjournment as he is likely to be engaged in the matter. Yeah, but
I'm great when I'm engaged.
you are already engaged.
I was engaged, that's why I.
Okay, just a moment. Yeah, he is not the advocate on record, but he has been engaged in this case. The learned counsel appearing on behalf of the respondent is also present. The records of this case has also been received from the concerned court. We have submitted where there is no perversity in the impugn judgment.
There is no iota evidence either oral or documentary to show that.
Just. The counsel for the appellant is seeking adjournment. No advance notice seeking adjournment was circulated.
But
Before
I
this vote.
was on the impression that nobody is appearing. Last time,
Notice हुआ है. How can you be under the impression that nobody will
because
appear?
when it was fixed, that
कोई
time
बात
nobody has appeared.
Uh,
That time nobody has appeared.
That's since no advance notice of adjournment has been circulated, and in order to give one opportunity to the appellant, the matter is adjourned and is directed to be posted on 3rd of March
My lords,
to be taken up at
there is difficulty for me, my lords. I have to take my daughter for medical treatments to CMC in that week.
तो आपको कब चाहिए?
If it is possible, my lords, on 24, 25, 27th, 28th of this month, if possible.
इस मंथ के लिए तो उनको चाहिए ही नहीं ना,
Then,
अगले साल रख देते हैं.
no, lords.
आप
That is
बताइए,
the
आप
difficulty,
बताइए
my lords.
डेट आप चूज करिए ना, मार्च का डेट चूज करिए.
Yes, my lords.
तो मार्च का तुमको वहाँ से नजर आएगा
बताइए
उस कैलेंडर में.
10th, 11th, 12th, any day, my lords.
on 10th, 11th, 12th.
Then 17th, 18th.
On 18th of March 2025 to be taken up at 2:15 as the first case, subject to deposit of cost of ₹10,000 in the वो advocate clerks का जो है ना association का सारा detail रहता है, bank account details सब. The if the proof of deposit is not filed in the registry by 10th of March, this appeal will stand rejected without reference to a bill.
Under heading for orders with defect, item 3, second appeal 34 of 2023 along with item 4.
आप लोग आपस में जो भी आपको प्लीडिंग चाहिए चेक कर लीजिए, रिकॉर्ड्स भी आया हुआ है. If you want to go through the records, in the meantime, if you give a slip to the court master, he will get the records for you. आपको slip देना पड़ेगा. उस दिन फाइल रिकॉर्ड पढ़ने के लिए टाइम मत मांगिए.
Your Lordship, the defect is surviving, Your Lordship, defect number 1, which says, Your Lordship, the suit and appeal value is missing in the certified copy of decree, Your Lordship. So for this, we have also filed IA for ignoring the defect, Your Lordship.
No, your court fees will be determined only when the suit value etc. is there. SA number 34 of 2020. As per the office defect, suit and appeal value is missing in certified copy of the decree under appeal of title appeal number 7 of 2015. And it has been stipulated that the decree be sent. So decree का ही defect है ना?
Yes, sir.
Decree be sent to the concerned court for correction. Office is directed to send the certified copy of the decree under appeal to the concerned court for correction. आप जमा करेंगे special messenger cost. Upon deposit of special messenger cost by the appellant by next Monday. By coming Monday. By coming Monday. Post this case on 17th of March the application. कहाँ का मैटर है?
इसमें जो सेकंड केस ऑफ डिफेक्ट हुई आइटम 4 इसके साथ में मिलकर ये डिफेक्ट हुई
थ्रू स्पेशल मैसेंजर, थ्रू स्पेशल मैसेंजर आएगा तो वहाँ अपने से ही आएगा. क्या बोल रहे हैं?
इसमें दो केस था आइटम 3 एंड 4 3 में डिफेक्ट था 4 में डिफेक्ट
तो साथ ही होगा ना.
आइटम 5 सेकंड अप्रैल 37 ऑफ 2023
मिस्टर शर्मा, आपका केस कॉल आउट हुआ था. नोटिस तो हम कर दिए थे, कॉम्प्रोमाइज का कहानी. वो तो कोई आया नहीं कॉम्प्रोमाइज के लिए.
इंफॉर्मेशन लॉसिंग उनको नोटिस मिल चुका है.
हाँ,
किसी
तो?
लॉयर को हायर किए लॉसिंग एक डेट दे दिया जाएगा.
जब आपसे कॉम्प्रोमाइज हो गई है देन इट मींस यू आर इन टॉकिंग टर्म्स.
लॉसिंग
आप तो पता करके रखो.
तो उसको एक डेट दे चुके किसी लॉयर को रखिए. हम पता करेंगे.
हाँ, इसीलिए पता करके रखो. 12 बजे पता करके रखो, क्योंकि सेकेंड अपील में ऐसे नोटिस नहीं होता. कॉम्प्रोमाइज आप बोले थे इसीलिए नोटिस किए. वो बता भी देंगे किसको जिस किससे बात हुई है उनको बुला के लेके आइए तब इसको एडजर्न करेंगे. ऐसे नहीं करेंगे.
आइटम 5
ये डिफेक्ट है क्या?
यस डिफेक्ट
Essay number 37 of 2023. Nobody appears. I have a time till 24th of February is granted to the appellant to remove the surviving defects. 20. Office is directed to communicate this order to Mr. Vikas Shadol, a soft copy. Who is the advocate on the matter? If the defects are removed within time, pose this case on 26th of March. ये प्रिंटरी ऑर्डर्स हैं, इसको आज अपलोड करना है.
Item 6 2nd April 38 of 2023
Okay, nobody appears. In spite of order passed by this court, the defects have not been removed. Order the date, the order dated 2/1/25. The defects have not been removed. However, time till 24th February is granted to the appellant to remove the surviving defects painfully or to file an appropriate petition seeking or to file appropriate interlocutory application in connection with one or the other defect, failing which this appeal will stand dismissed without reference to bench. In case needful is done in terms of this order, pose this case on इसमें कौन सा डेट है? 26 फरवरी
March.
26 मार्च का डेट दिया है सर। और टाइम कब तक का दिया है? अब हो गया उसका कोई बात नहीं, लेकिन इतना लंबा टाइम नहीं काम करना। इसमें पोज दिस केस ऑन 5th of March on the application. मुझे 24 तारीख का टाइम दिया है ना, क्योंकि 25 मार्च का डेट दिए है, उसको थोड़ा एक्सटेंड करके 5th मार्च तक कर देंगे। ठीक है, प्रीवियस ऑर्डर में थोड़ा कर ही लेंगे, वो टाइप कराना।
Item 7, second appeal 41 of 2023.
Earlier only defects were removed. And there was further stamp reporting needed.
Defects have been removed.
Yes, the court fees has been.
Orders with defect. IE number.
Last order.
It has been reset.
So you are just second.
Petition it may be posted under the appropriate heading.
कोई बात नहीं, आप पढ़िए।
Petition it may be posted.
नोटिस नहीं दिया है। Notice से आपको नहीं देखी। Notice is already there, that it is under the heading for order 41. You did it. There is already a notice. बताइए इनको notice नहीं देखी। Promise नहीं।
Select the supplementary.
देखिए।
देखिए इधर आपको भी 11
Yes.
Petition it may be posted at
Item 8, second appeal 201 of 2023.
Supplement.
Should we have applied for the certified or we have received it? Should we have applied?
It's a defective.
Yes. Judgment, certified copy of the judgment. was certified. We will filing by today so that there is further stuff.
Just a minute. Second appeal number
201.
201 of it. Also for the appellant is present. Time till 24th February is granted to the appellant to file, to remove the surviving defects / to file appropriate interlocutory application. If this order is complied, pose this case under appropriate heading on 27th of February. कई सारे डिफेक्ट्स हैं, देख लीजिए। आपने देखा है?
I have noted down.
Item 9, second appeal 203 of 2023.
सेकेंड अपील सेकंड में बोलूँगा कोई भी केस को फर्स्ट अपील सेकंड अपील रिजेक्ट करने के पहले, प्लेटफॉर्म करने के पहले एडवोकेट को फोन करते हैं। छोटा चीज़ के लिए केस रिजेक्ट नहीं करते, है ना? फोन करके बोल देंगे भाई ये बहर है, मिसमैच होता है, ऐसे नहीं केस डिस्कस करना। यस,
Yes, that's in compliance with Objection 2 and 25. The remaining defects were removed, my lords. There were 3 remaining defects that has been removed, and now, lordship, there has been a further stamp reporting. court fees is required to be paid, my lords. I'm paying just for a week's time, my lords.
It's a short.
Yeah, I will, my lords. I will, just for a week's time, I will remove.
Rest of the defects you have removed?
Yes, yes, I have removed.
Counsel for the appellant is present. Time till as paid. Time till 18th February is granted to the appellant to remove the subordinates entry. If the defects are removed within time, close this case and the appropriate heading on 20th.
20th.
Please.
Okay.
Item 10, first appeal 216 of 2023.
Two IAs have been filed. One for the limitation, my lord. There is a limitation of 216 days, my lord. And
This is first appeal.
yes, my lord. Paragraph 6 onwards, I have
How much is the delay?
delay of 216 days.
What is the reason?
Reason I am stated in para 6 regarding that the appellant number 2 was posted as a inspector BSF in Rajasthan, appellant number 3 was deputy command BSF in Punjab, appellant number 3 all were outside my lord, maximum of the appellant. And
What is the other IA?
other IA is for expunging the name of plaintiff number 2 has not been made party in the instant memo, my lord. And already in original suit number, she was right and she was deleted by order dated 22/2015, but the same was not incorporated in the judgment and degree. And her legal heirs are already party in the present first.
They were deleted.
Yes, my lord. Yeah, I have stated that paragraph 4 and 5 of the IA, my lord. Same was not deleted from the arrays of the party in judgment, my lord. Already our legal aids were arrayed as plaintiff number 2, B, C, D, E, and then also applied before this honorable court.
आप किसकी तरफ से?
State.
State is the party.
Yes, ma'am. 1, 2, 3. State and Electricity Board. First I is 1276 regarding limitation method. From para 6 to
तो वो ऑर्डर शीट तो आपने लगाया नहीं आइए के साथ हाँ? And if this is correct, but the degree भी गलत है है ना? There is an error in the degree then.
correction.
Correction हो जाएगा तभी ना?
Yes, correction हो क्या?
तभी होगा.
Yes.
LP number 216 of 20. Counsel for the parties are present. Counsel for the appellant has submitted that IA number 1277 of 2025 has been filed. In view of the defect number 5, wherein the office has pointed out that plaintiff number 2 capital A has not been made party in the instance. The learned counsel has referred to paragraph 4 of the interrogatory application to submit that plaintiff number 2A in the suit being original suit number 43 of 2013, namely Masomar Madhuri Devi, wife of late Fauzi Singh, who was originally plaintiff number 2, died and she was deleted by order dated 20/2/2015 was deleted?
मौसमत माधुरी देवी
आप ऑर्डर शीट लेके आइए, हम ऐसे नहीं करेंगे. By order dated 22, ऐसे लिखिए, मौसमात माधुरी देवी was deleted by order dated 22/2015 before the learned court. Correct?
Yes.
However, the order sheet has not been annexed with the implementing application. At this, the learned counsel for the appellant prays for adjournment.
We file supplement regarding
Annex
the
करना
order.
पड़ेगा.
Yes, madam, will annex.
और उनका डेथ सर्टिफिकेट भी चाहिए. बिना डेथ सर्टिफिकेट के कैसे हो?
अगर उस ऑर्डर में वहाँ पे हो गया
मैं ये प्लेंटिफ नंबर
2 का वहाँ ऑर्डर शीट में तो इनकॉर्पोरेट हो गया होगा,
क्या होगा?
सब्स्टिट्यूशन हुआ होगा, द मैरिज ऑफ पार्टीज.
नहीं, ये कौन who died before judgment, ये किसके बारे में आप बोल रहे हैं?
जिनका डिफेक्ट है हम पार्टी नहीं बने, उनका लीगल हेयर पार्टी बने हुए.
आप हमको बताइए, हैज पास्ड अवे बिफोर द जजमेंट एंड डिक्री, ये किसके बारे में आप बोल रहे हैं?
द ओरिजिनल प्लेंटिफ.
आप ऑर्डर शीट देखिए. एक जगह यहाँ पे लिख रहे हैं माधुरी देवी हैज डाइड ऑन 12/9/2021. यहाँ पे आप लिख रहे हैं डाइड एंड डिलीटेड ऑन 22/2015. क्या बात?
ये दो डिफेक्ट है मैडम. 2 है उसमें 2 का है,
और
एक माधुरी देवी का है, एक मौसमत माधुरी देवी. हम ऑर्डर शीट लगा देते हैं.
ये एफिडेविट के साथ सप्लीमेंट्री एफिडेविट फाइल करिए.
Supplementary
ये
file
ना तो आपका ये सेंटेंस का कोई मतलब निकल रहा है. अगर इंग्लिश नहीं सक रहे हैं तो हिंदी में बना लीजिए.
Yes, ma'am.
ठीक है? सेंटेंस को ठीक से नहीं लिखेंगे तो कैसे ऑर्डर होगा? और जिसके डेट की बात कर रहे हैं, जो डिलीट हो चुका है उसकी बात दूसरी है. लेकिन अगर इस वक्त आप किसी की भी डेट की बात कर रहे हैं आफ्टर द जजमेंट, यू हैव टू एनेक्स द डेथ सर्टिफिकेट.
That's it.
उसके बिना हम आपका इस पिटीशन को एंटरटेन नहीं कर सकते.
Yes. We'll file a supplementary affidavit regarding this.
लिखिए. FA number 216 of 2023, counsel for the appellant prays for time to file supplementary affidavit in support of IA number 1277 of 2025, annexing the order sheet of the learned court dated 22/2015, and also annexing the death certificate of one or the other person who is said to have expired on 12/9/2021. कैसे दो?
डेथ का डेट नहीं लिखा हुआ.
Who has said to have expired चलिए कोई बात नहीं, that should be sufficient.
ऑर्डर शीट लगा दें रिगार्डिंग लिमिटेशन.
क्या करेंगे limitation?
Yes.
In the meantime, the counsel for the respondents may seek instruction and if so advised file a response to the petition for confirmation. Post on 11th of March. ठीक है? The supplementary affidavit / reply to the limitation petition be filed latest by 7th of March.
Yes.
Item 11, first appeal 50 of 2024.
This is part of the batch matter that is posted for July.
It will come at 2:15 बजे साथ में. कब 2:15 की 12 बजे. वो जो डिफेक्टिव इनका बैच है ना उसके साथ ही है.
Under heading for hearing under order 41 rule 11 of CPC, item 21 wrongly in daily list, item 22 SA 148 of 2019. Sorry. Under heading for admission, item 19 WPC 1348 of 2017.
Serial number 19. Bring for short answer.
When will your senior be available? Not Passover means what time?
Maybe after
After?
check to
You find it out. Right? Your senior is a busy counsel. So you just let me know what time will suit you.
it was going serial wise. I mean 19. I didn't check it out.
It is going serial wise.
And 11 was small. I'm sorry,
We are going serial wise. As per our norms, we go by serial. We go in serial.
As part of a few cases.
Item 11 passed over.
11 has been passed over. आके हमको बताइए कितने बजे करें. State is also not there.
Item 20, first appeal 120 of 2024.
This is appeal. First appeal against the decree.
Yes.
This is coming for the first time.
FA number 120 of 2024. Also for the appellant is present. Let this appeal be admitted for final hearing. Let this appeal is admitted for final hearing. Issue notice to the
So this
there are two
is the type. Yes, both of them. Send them to
the respondents. For which requisite under ordinary process and speed post with respect to respondent number 1 and speed post with respect to respondent number 2 be filed within by next month.
bit more time because otherwise I would have done it today itself. My clerk is not here, he has gone to Allahabad. I am here.
Be filed by 24th of February.
Yearly.
24th of February 2025. Office is directed to call for the records from the concerned court. Let this order be communicated through fax. Close this case on 24th March. Under appropriate heading, office to track speed post delivery and prepare appropriate office note with regard to service. 1 का ordinary के साथ speed post है.
Second just.
Second का सिर्फ speed post है.
Yes.
Ordinary पहुंच नहीं पाया.
Yes, I understood.
Item 22, second appeal 148 of 2019.
Mr. Roy, in one of your cases, it was a defective.
Yes.
I have given time for removal
Yes.
of it. You will get a copy of the order, or you can just check it.
Yes. In this case, when respondent number 1 is right. Just got information day before yesterday. Respondent number 1 is right. Siraj and
SA number 148 of 2019. The left counsel for the appellant has submitted that the respondent number 1 has expired during the pendency of this case.
Yes.
During the pendency of this case, he prays for time.
2 weeks, but legal representatives have filed the information.
close this case on 27th of February under the heading for all this.
Item 23, second appeal 174 of 2019.
Appellant. Where is the appellant? आप क्यों देख रहे हैं इस केस को? आपके सीनियर का केस है।
For serial number 19 with us, and
19 क्या हुआ? हाँ, yes.
and due to some personal difficulty, the senior couldn't be in court premises in his first half. We didn't get the second half.
Can you ask him to come at 3:30?
Okay.
What's your name?
K. Hari.
Sorry?
K. Hari.
K?
Hari. H-A-R-I. Hari.
Very, very bright, so you prepare this. Which college have you passed out?
Chota Nagpur Law College.
When, how many months of practice have you?
No, it's 1 year.
1 year, 12 months.
Yes.
You go through the record,
Yes.
okay? Your senior may still remain busy.
No, I really.
देखिए ऐसे नंबर 174 of 2019 by order dated 14/10/2024 the matter was adjourned at the request of the appellant who had prayed for time to advance arguments in the matter of admission, and the prayer was allowed by way of last chance. Today, nobody is appearing on behalf of the appellant, nor any adjournment slip. Any request for adjournment has been circulated. Accordingly, this appeal is dismissed for non-proceeding. शेयर कोड करके कम्युनिकेट करना।
Item 24, second appeal 181 of 2019.
Praying for Passover.
In this case, I have filed one IE application, my lord. And in this case, the execution proceeding has been finished, my lord, with full satisfaction.
That's right. If the execution is finished, that does not mean that the case will be coming from, isn't it?
My lord, possession has been given.
Maybe possession has been given.
The out of court settlement,
Because out of court settlement, the possession has been given.
my lord.
Where is the order of the execution case? So
Yes,
nothing survives.
Nothing survives.
Where is the execution?
Yes, I have filed in my lord's order in IE number 108/2025.
चलिए पढ़िए जरा.
Oh, yes.
Order dated 13/12/24.
Yes, attendance has been filed on behalf of the plaintiff. Today petition has been filed on behalf of the plaintiff with a prayer to dispose of the case. Learned counsel on behalf of the plaintiff has submitted that above execution case has been filed by decree holder for executing the decree passed in eviction suit number 696. It has been further submitted that the decree holder has put possession over the property under execution. It has been further submitted that the judgment debtor have voluntarily handed over the vacant possession of the property under execution, so the decree under execution becomes fully satisfied and the decree holder has no grievances against the judgment debtor. It has been further submitted that dispute between the decree holder and judgment debtor with respect to the property under execution has been settled outside the court, and there is no grievance. It has been lastly submitted that under the above set circumstances, this execution case may be disposed of in full satisfaction. Heard the parties and peruse the report. From the perusal of the case report as well as the petition dated 5/12/2024, I find that the decree holder, namely M.D. Jubair, has filed the execution case against the judgment dated, namely Ras Bihari Pandey and others. It further appears that presently the case record is running at the stage of awaiting order from the Honorable High Court in second appeal, and the decree holder has expressed his desire not to pursue the matter any further and want to dispose of the execution case in full
So
satisfaction.
you have withdrawn the execution case.
No,
Who are you? The execution case was filed by the decree holder.
yes, my lord.
Decree
I am the
holder
landowner, my lord.
Sorry?
I am the landowner. Landlord, I am the landlord. It is out of eviction suit, my lord.
Okay. And they are the tenant.
They are the tenants.
Now you have already received the possession.
Yes.
And that okay. And you have closed the execution case.
They are
At
present
your
in the.
inst-
They are
At
present.
your instance, the execution case has been closed. Landlord must be the executing.
Yes, yes.
Decree holder was landlord.
Yes,
landlord.
Yes.
He must have filed an execution case.
My lord.
At the instance of the landlord, the execution case has been closed.
My lord.
This is what you want to say.
Due to out of court settlement.
We do not know whatever be the reason.
It
But
has to-
according to you, you will not execute the decree. Whatever it is,
Possession has been given me. Then
whatever it is, the execution case is closed. You are the decree holder, and at your instance, the execution has been closed. Correct?
my submission is that my execution is complete. Possession has been given me, and I have taken over the possession and out of court settlement matters and
We do not know anything. आपने execution बंद करा दिया ना?
जी.
खत्म हो गया execution. Now they have no apprehension of eviction. क्योंकि ये already evict हो चुके हैं वहाँ से.
Yes.
But still they are fighting.
I mean, my humble submission is that, my lord, when the execution proceeding has been completed with full satisfaction, there is nothing to remain to decide in this appeal. And so this appeal has been appealed.
इनको तो notice भी नहीं हुआ था execution.
नहीं हुआ है, पार्टी हाजिर है हुजूर.
अच्छा.
हाँ.
Was present.
Yes, yes.
From where do I get presence?
Yes, attendance has been filed on behalf of the plaintiff and आया है हुजूर यहाँ पर.
कहाँ?
ये हम इसमें दिखा देंगे.
दिखाइए.
Heard the parties and perused the record.
और the parties मतलब क्या? Attendance तो खाली plaintiff का दिख रहा है.
हमको पूरा order sheet लगा
पूरा
देंगे.
option का बात नहीं है. जो दिख रहा है हम उसकी बात कर रहे हैं.
Present, the lady is present, my lord.
अच्छा. आपको किस लिए टाइम चाहिए? कोई पर्पज ही नहीं है आर्गुमेंट का. आपने इविक्ट करके हैंड ओवर कर दिया और एग्जीक्यूशन केस क्लोज हो गया. ठीक है, तो बुलाइए उनको. आइए 12 बजे.
आइटम नंबर 24
आपका डिसमिस कर दिया.
24 नंबर गलती हो गई है. 24 नंबर कह रहे थे सेकंड अपील में गलती. हम तैयार है अभी बहस के
आपको
लिए.
कितना बार बोल रहे हैं 2-4 जूनियर रखिए, सुनते
नहीं
नहीं.
नहीं
बात.
है मतलब
कहाँ है आपका? कोई जूनियर आपको नहीं दिखा.
गलती हो गई. हम क्या बोलते
एक जूनियर को परमानेंटली यहाँ रख दें.
हैं. जी जी
किसको रखेंगे? उसको बुला के लेके आइए.
नहीं जूनियर तो है ही. बट आज ऐसा हो गया कि हर कोर्ट में लग गया, सब एक कोर्ट में सब चलेंगे. हम 24 में बहस
2-4 जूनियर और भी चाहिए ना.
नहीं रखेंगे.
आप नहीं रख रहे. एप्रोप्रिएट जूनियर आप नहीं रख रहे. एप्रोप्रिएट नंबर.
हम तैयार हैं.
आपके साथ रहेगा तो कुछ सीखेगा ना.
जी
हम लोग का यही कंसर्न है.
जी
देखिए ऑर्डर एक बार हो जाने के बाद रिकॉल करना बहुत मुश्किल है। मे बी दैट द अदर साइड इज वाचिंग, वी डू नॉट नो व्हाट
Judgment of reversal है
नहीं। आपकी बात सही है, लेकिन नहीं कर सकते हैं ऐसे, थोड़ा मुश्किल है।
गलती हो गई।
आप रेस्टोरेशन फाइल करिए, आप रेस्टोर
नहीं हम रखेंगे जूनियर एकदम हम रखेंगे।
नहीं आप देखिए, आप समझिए इस बात को, लोग रिकॉर्डेड प्रोसीडिंग देखते हैं, उसके बाद देखकर
एक
अपना
केस के चलते खाली हो गया।
आपकी बात सही है,
हम
लेकिन
24
ऐसा नहीं कर सकते।
24
जिस केस में ऑलरेडी बाय वे ऑफ लास्ट चांस हो चुका
नहीं,
है,
हम एकदम तैयार है।
ऐसा नहीं कर सकते।
एक बार माफ कर दीजिए।
नहीं आप रेस्टोरेशन फाइल करिए।
बहुत अधिक पार्टी बहुत दिक्कत हो रही है। बहुत दिक्कत हो रही है।
जिस केस में नोटिस ही नहीं इशू हुआ, उसको रेस्टोरेशन में भी दिक्कत है।
नहीं उसमें फिर रिस्टोरेशन में नोटिस होता है। पहली बार गलती हो गई, आज बार माफ कर दीजिए। आज बार माफ कर दीजिए। हम 24 में हम कर रहे हैं।
अरे एक सेकंड इनका कर।
An application has been filed on behalf of the
Yes.
respondent, saying that the matter has been compromised among some of these co-sharers. Not this.
इनका ये कहना है, he is the decree holder.
Yes.
He says that the execution has
It may be, but if I succeed in the appeal, then that will be restored under section 144 of the CPC.
Certainly.
If I succeed.
But he is talking about some compromise.
I will have a talk with the, that is the reason I was going to submit.
कहाँ का है आपका पार्टी?
रांची का ही जो है हम बुला सकते हैं, कल रख दीजिए।
हाँ कल रख देते हैं।
कल हम
ऐसे नंबर 181
हम चाहते थे कि वो जो सेकंड हाफ में, लेकिन वो शायद आएगा नहीं आएगा।
कल सेकंड हाफ आज आ सकता है सेकंड हाफ।
हाँ कल सेकंड आराम से।
कल सेकंड हाफ। ऐसे नंबर 181 of 2019.
If they are not interested, why I should pass?
For the parties are present, an interlocutory application being IE number 108 of 2025 has been filed by the decree holder by stating that the execution case has been closed.
Yes. Drop.
Has been dropped on account of compromise between the parties.
Yes.
Counsel for the appellant submits that the matter be posted tomorrow at 2:15.
Yes.
And he shall seek instructions and inform the
Yes. If there had been a
post
compromise.
at 2:15 to be taken up as a first case.
Item 23.
This is defendant number 6 second appeal against the judgment of reversal. The plaintiff filed title suit claiming 1/3 share of the suit property. During the pendency of this case, Lordship, the defendant number 6 to 13 purchased the land. Thereafter, Lordship, the defendant number 6 to 13 filed an application under Order 1, Rule 10, Sub Rule 2 CPC for being implicated as a party defendant which was allowed, Lordship. The case of the plaintiff is that plaintiff filed title suit claiming 1/3 share of the suit property, Lordship. The Fulchand Gwala had 4 sons, Lordship. Fulchand Gwala had 4 sons, Lordship. Shivdayal, Gyani, Hiraman, and Somar. And Somar died issueless, Lordship. The Fulchand Gwala Lordship having 2 immovable property, that is village Korra, Khata number 22.
That's right. Okay. 2 property. Then
Lordship, the disputed property is that the village cantonment Khata number 154 having an area 3.21 acres, Lordship. Now
why it's a partition? So
partition suit.
why only one property is disputed?
Lordship, there is a findings of the land trial court, Lordship. There was previous partition, Lordship, and Exhibit 2 admitted by the plaintiff that, and in para 17 of the written statement also admitted there was a previous partition, Lordship. I am coming, Lordship. May kindly see, Lordship, issue framed by the learned trial court, Lordship. Issue para 12, Lordship. Issue number 7 and 8. Para 12, Lordship.
Yes.
Are you Lordship got it?
Yes.
Yes. Is there any unity of title and jointness of possession between the parties over the suit lands?
are the plaintiff entitled to get a decree for partition of their 1/3 share over the suit land. Now, Lordship, make entry findings, Lordship, para 22 of the learned trial court. Para 22, Lordship. Of the learned trial court, Lordship. May I read? From the pleading the evidence used on behalf of the plaintiff, it appears that other ancestral landed property of the party, that is lands of Khata number 22 of village Kora and Khata number 154 of village cantonment, except the plot number 196 of the Khata number 154, have already been partitioned between the plaintiff and defendant, and plaintiff are in separate possession of their share of the lands as allotted them. The plaintiff have also received consideration amount of other land of Khata number 154 as per their share, which has been earlier sold. So from the above part of the pleading and evidence, I find that previous partition joint property by meets and bonds, and accordingly separate possession over the their respective share of land is admitted by the plaintiff themselves. It is settled law that admission is the best evidence unless it is satisfactorily explained. The law provides that once it is proved or admitted, there has been already been partition with respect to some property. The presumption will be that there had already been complete partition, but I find that plaintiffs have not furnished any explanation either in the plaint or evidence as to why plot number 196 of the Khata number 154 of the village cantonment, of which the partition is sought in the suit, could not be partitioned between the parties earlier, though it was joint family property. Under such circumstances, one is upon the plaintiff to prove the above more facts. Moreover, the plaintiff have to prove their own case. This is important. The plaintiffs have themselves filed Exhibit 2, which is certified copy of the sale deed dated 17/7/1954, executed by Sri Dayal Gop, Gyani Ram, and Mosmat Kunti, the wife of late Hiraman Gop, in favor of Ravneshwar Prasad Burma in respect of 73 dismissal of land of plot number 624 of Khata number 154. The suit land in respect of which partition is sought also appertain to some Khata number 154. From the perusal of Exhibit 2, I find that Sri Dayal and Gyani Ram, the father of the original plaintiff number 1 and grandfather of the plaintiff number 2, 3 and 4, the wife of Hiraman, have transferred and sold the land of 624 of Khata number 154 together through aforesaid Exhibit 2. The recital of Exhibit 2 clearly shows that the executant of Exhibit 2 have admitted the lands which belong to sold, although recorded in the name of Sri Dayal, but his brother also possession over the same. As per the partition, they are disposing the land to satisfy their own personal necessity. The relevant part of the recital Exhibit 2 in this regard is also followed. Mawadi 73 डिसमिल जमीन हकीकत रहती कायम जो नाम से सिरदयाल गोप बेरादार मौके नंबर 1 भैंसपुर मौके नंबर 2 को दर्ज पाया। खास में तीनों साहबदरन बजरी बंटवारा के अलग अलग दखलकार चले आ रहे हैं, ये एडमिट कर रहे हैं। अब पारा 17 में भी एडमिट कर रहे हैं कि हम सब पैसा ले रहे हैं। रिटिन प्लेन को कॉपी दिखा रहे हैं।
आगे बढ़िए
जी।
So the executants
So the executants, including the father of the original plaintiff number 1 and grandfather of plaintiff number 2 and 3, have already admitted in Exhibit 2 regarding partition of land of the plot number 624 of Khata number 150. Thus, the execution of the sale deed in the year 1954 by the Sri Dayal Gyani and Mosmat Kunti established the fact prior to 17/5/1950 they had partitioned the lands, including the lands of Khata number 54, and that is why they jointly executed the sale deed. If the land was not joint at the time, then the Sri Dayal was also competent to execute the sale deed in the capacity of the Karta of the family. So I have stated even plaintiff have also admitted their pleading. They have already received their share of the consideration amount of other land of Khata number 154, which have been sold and transferred earlier. We saw that there was a partition between the parties, as only in event of partition, member of joint family become entitled to get the definite share either in the movable property. Though the Exhibit 2 is not a deed of partition, but it is a relevant document which contains admission of the ancestor of the plaintiff regarding previous partition. As I have stated above, the law provides that once it is proved or admitted, there has already been partition with respect to some property, the presumption will that there had already been complete partition unless it is reverted. But the plaintiff
ये कहाँ से ऐसा कोई law है
law तो है
कि अगर if there is a partition in connection with some of the property, there is a presumption that
but admitted that lordship. The disputed land is
आप मेरा
recorded.
बात भी सुन आपसे पूछ रहे हैं
जी
कि अगर मान लीजिए किसी केस में there is a story of partition with respect to only some of the properties, then can there be a presumption that the entire family property has been partitioned?
but lordship, in this case there is only one plot is
केस
left.
से थोड़ा बाहर निकलिए ना, प्रिंसिपल ऑफ लॉ की बात करें. If there in a case there is an averment that there was previous partition in connection with some of the properties, is there any presumption that the entire joint family
No,
property has been partitioned?
it is not.
So यहाँ कैसे लिख रहे हैं?
It is not.
As I have stated above, the law provides that once it is proved or admitted that there has already been a partition with respect to some property,
Admission is
the
different thing.
presumption will be that there has already
No.
been completed unless it is
नहीं वो तो नहीं होगा but it is also presumption they admitted that there was a previous partition in para 17 of the plaint lordship. This is very much important lordship.
आगे आगे बताएंगे.
हम para 17 दिखा रहे हैं.
नहीं इसको complete
जी.
कीजिए.
I find the plaintiff has not adduced any reliable or satisfactory evidence to prove the fact that the suit land is still joint. In view of the above facts and circumstances evidence available on the record, I find in whole that there is no unity of title in possession between the parties in respect to suit land, and entire joint family property, including the suit land, has already been partitioned between the parties. The suit is not liable to be partitioned as claimed by the plaintiff. Accordingly, issue number is decided
So it
against
was in your favor.
मेरे फेवर में.
Appellate court क्या?
अपीलेट कोर्ट जो एग्जिबिट 2 में एडमिशन है और पारा 17 का जो एडमिशन है उसके बारे में कोई फाइंडिंग्स नहीं दिए हैं. थोड़ा सा मुझे हम प्लेंट दिखा दें आपको.
नहीं प्लेंट नहीं है, हम एडमिट करेंगे ना, आपकी बात को तो हम सच ही मान रहे हैं.
हाँ
हम कहाँ आपकी बात को डिस्प्यूट
जी.
ठीक है, आप हमको बताइए वेयर इज द appellate court judgment?
लॉर्ड तो पारा 21 लॉर्ड तो पॉइंट 4 डिटरमिनेशन लॉर्ड पारा 21
The self-acquired property.
सिवदयाल के नाम से जो डिस्प्यूटेड प्रॉपर्टी उससे सिवदयाल ग्वाला के नाम से ही है.
अच्छा.
मगर जब
The
से
ancestor.
हाँ
Common ancestor.
यस कॉमन एंसेस्टर. मगर जब सेल डीड एग्जीक्यूट हुआ तो चारों के नाम से हम लोग एग्जीक्यूट कर दिए और उसमें जो है एडमिट भी कर रहे हैं कि हम लोग को प्रीवियस पार्टीशन हो गया है और प्लेंट में भी लिख रहे हैं कि हम लोग को प्रीवियस
Was it the case that it was the self-acquired property of?
नहीं लैंड वाज रिकॉर्डेड इन द नेम ऑफ सिवदयाल ग्वाला इन रिकॉर्ड ऑफ राइट लॉर्ड्स.
And he was not a party, no?
No.
Shivdayal Gwala was never a party in the suit. He
No.
must have expired.
Expired.
So ये point of determination क्यों बना?
The point of determination to be बना है तो इनको तो बनाना है 4131 में according to CPC law.
नहीं आखिर this it is nobody's case that it was his self-acquired. It was his property.
Yes.
इसमें कहाँ कोई dispute?
नहीं कोई dispute नहीं है.
इसका question क्यों बना?
लर्नेड फर्स्ट अपीलेट कोर्ट में जो बनाया
नहीं आप कुछ तो कारण होगा ना.
नहीं कुछ कारण है यहाँ देखा है देखा जाए.
And what is the second point of determination? ये point number 2 का क्या बताइए?
whether they are in unity of title and jointness. इनका
Point
कहना है
number 2 का
आप-
decision बताइए. कहाँ?
point number
23.
page 23.
Right. Finding खाली
इसका फाइंडिंग है पारा 27 लॉट्स पेज 20 लॉट्स इंटरनल पेज 20.
Yes, पढ़िए सर.
Thus, from the careful perusal of the evidence of the witness of the defendant, it appears that several purchasers of the suit property have appeared and given evidence, but it is clear from the deposition that they do not have any knowledge about the family members of the plaintiff and defendant, their property, or they also do not have any knowledge whether there was previous partition between. And this is a reference to the evidence of DW3 is required to be made, where he has clearly admitted in para 23 of the cross exemption that the sons of the Phulchand Gwala had not partitioned the land in between themselves. Again, in para 38, he has reiterated that all the lands of family of the Phulchand Gwala was not partitioned. DW11 has stated in para 23 about the joint position of the Phulchand Gwala and his sons of lands of Khata number 154. And lastly, DW22 has stated that the partition suit is proper and valid. Apparently, these witnesses are appearing for the defendant. They have stated about the non-partition of the land and jointness of the parties, thus have supported the case of the plaintiff. Besides, I would like to refer the Exhibit 2. Exhibit 2 is the sale deed, that is the Exhibit B is the and Exhibit 2 are the same documents. It is the sale deed executed by the C. Dayal Go, Gyani Gop and Mosmat Kunti Devi jointly in favor of Ramneshwar Pasal Banwa in the year 1954. It goes to suggest the property was joint property. Although the land was recorded in record of right in the C. Dayal Gwala Lordship, but the sale deed executed by the four brothers Lordship. Therefore, there is a findings of the London Appellate Court that it is a joint property Lordship. But ignoring the para 17 of the admission of the
What was the admission?
para 17 Lordship.
Do they admit that it was a joint family?
No. I'm reading up. Para 17 Lordship. The plaintiff number 1, his father Gyani, all along received their share of consideration money in sale of remaining lands of Khata number 154, which was all along being made by the C. Dayal Gwala as being Karta of the joint family. He admitted that he has received all the consideration amount. Lord, may can listen.
बताइए कौन हाँ है आपका substantial question?
Substantial question. Page 8, Lordship C or E, Lordship. C में है कि whether in view of well-settled law, the burden rests upon the plaintiff to prove the land of Khata number which is still recorded in CS Khatiyan exclusively in the name of C. Dayal Gwala was joint and rendered court below urged in deciding the issue number E important also. Whether in view of the admission made by the plaintiff in para 15 of the plaint, in the recital of the exhibit.
की बात कर रहे हैं आप इसमें?
जी?
ये तो 15 की बात कर रहे हैं आप?
नहीं वो गलत टाइपोग्राफिकल कर रहे हैं वो 17 होना चाहिए।
अगर ये पैरा 15 को लेकर हम एडमिट कर देंगे तो पैरा 17 को लेकर डिसाइड कर पाएंगे?
नहीं इसमें तो 17 ही होगा।
Are you sure?
Yes, हम तो लॉट से देख लिया जाए प्लेंट भी ना है।
हम आप ही के समझ में लिखेंगे आगे बताइए। आगे पढ़िए
जी। The learned appellate court will ought to have held that under the law all lands of Khata number 22 of village Kora and Khata number 150 Modak shall be presumed to have been partitioned. As such, plaintiff failed to plead and prove that under any agreement during earlier partition suit land was kept joint. They are not entitled to claim the partition of the suit landlords. रिकॉर्ड ऑफ राइट में मेरे नाम से सी दयाल ग्वाला के नाम से बट सील्डिट एग्जीक्यूटिव है 4 भाई के नाम से इसीलिए लोअर अपीलेट को बोल दिया कि इट इज जॉइंट प्रॉपर्टी लॉ।
आपका प्रीवियस पार्टीशन का कहानी कब से है?
जब से हमारा CS रिकॉर्ड ऑफ राइट में मेरा हुआ है।
प्रीवियस पार्टीशन का कोई डेट है?
नहीं, डेट तो नहीं होगी, उनका एडमिशन है प्लेंटिफ का।
फिर भी कब है ये प्रॉपर्टी?
नहीं, डेट नहीं है उनकी, मगर एग्जिबिट 2 में वो एडमिट कर रहे हैं कि प्रीवियस पार्टीशन हुआ है एग्जिबिट 2 में, और पारा 17 में भी एडमिट कर रहे हैं कि उस प्लॉट का खाता नंबर 154 का इंटायर कंसिडरेशन अमाउंट भी हम ले चुके हैं, पारा 17 में उनका एडमिशन है।
दिखाइए सर।
जी।
See, this particular property, which was consideration money की जो बात है, this particular property was sold by all the four brothers jointly.
Yes.
Right? तो ये consideration money तो सभी को मिला होगा ना?
नहीं, कि लिखे हैं कि हम सब 154 का पूरा कंसिडरेशन मनी ले चुके हैं, इनको पूरा
किससे
पैसा
ले चुके हैं?
वो तो नहीं लिखा, मगर लिखे हैं कि एडमिशन है कि हम ले चुके हैं पूरा कंसिडरेशन का मनी, मीनिंग ये दिया दिया।
किससे लिए हैं? आप ही को ना बेचे थे?
नहीं, हमको नहीं, हम तो डिफेंड जो ओरिजिनल डिफेंडेंट है वो 1 to 4 है, उससे परचेज किया ड्यूरिंग द पेंडेंसी ऑफ द पार्टीशन सूट।
पेंडेंसी?
हाँ, हम ड्यूरिंग द पेंडेंसी में फिर हमने पिटीशन फाइल किए 1 टाइम का, तब मेरा अलाउ हुआ है। उन लोग तो अब छोड़ चुके हैं, जो बेच चुके हैं तो छोड़ चुके हैं, उनको कोई मतलब नहीं है केस से, हम लोग परचेज किए हैं।
Defendant number 1 to 4 are the descendants of Shivdayal.
Shivdayal.
And they have sold the property.
Yes.
The property was recorded in the name of Shivdayal.
Shivdayal.
And a partition suit was filed seeking partition of this property by saying that it's a joint family.
Joint family property.
The plaintiff claimed that there was a previous partition.
No, plaintiff claiming it is a joint property.
It's a joint property. The defendants claimed that there was a previous partition.
There is a previous party. There was a previous partition. तो डिफेंडेंट नंबर 1 जो सिद्धेवाल के जो लीगल है तो बेच चुके हैं, उनको अब प्रॉपर्टीज को लेना देना नहीं, हम लोग तो परचेजर हैं।
यहाँ पे कहाँ बोल रहे हैं? इसी the Chanu, the plaintiff number 1, the plaintiff number 1 and his father, Gyani, all along received their share of consideration money in the sale of the remaining land of 150, khata number 154, which was all along being made by Shivdayal as being the karta of the joint family.
मेरे एग्जिबिट 2 में ही इनका है एडमिशन है कि पार्टीशन हो चुका है, प्रीवियस पार्टीशन।
Or the learned counsel again on behalf of the appellant. The learned counsel for the appellant submits that the appellant was defendant number 6 in the suit and was the purchaser of the property from the defendants.
From the defendant of 1 to 4.
Defendant number 1 to 4, who were the
legal heirs of the
legal heirs of
Shivdayal Gwala,
Shivdayal Gwala, in whose name the property was recorded.
in CS record of right.
In CS record of right. The learned counsel submits that the defendant became a party as he purchased, defendant number 6 became a party and as he had purchased the property during the pendency of the suit.
No.
By virtue of filing a petition under Order 110. The learned counsel submits that so far as the trial court is concerned, the suit was dismissed.
Suit was dismissed.
On contest, and it was held that there was no unity of title and possession between the parties, and also observed that there was previous partition.
As admitted in Exhibit 2 of the.
That's it. That's too bad. However, the learned appellate court has reversed the
Here that it further goes to suggest that there is no partition with respect to the suit property.
and observed that there was no partition of the suit property.
Yes.
The learned counsel for the appellant has submitted that there was admission in paragraph 17 of the written statement filed by defendant number 1 to 4 that the suit property was a joint family property.
And Exhibit 2 also, Lords.
Exhibit 2.
Exhibit 2.
And in the exhibit 2 also it was mentioned that it was a joint family property. And
There was a previous
and-
partition. It admitted that there was a previous partition.
the learned counsel has submitted that in paragraph 17 of the written statement filed by defendant number
But I was the plaintiff's Lords.
written submission.
नहीं plaint में हो गया.
Okay. In the plaint filed by the plaintiff, ये तो आप admission क्या है 17 में?
नहीं Exhibit 2 में भी admission है. There was a previous partition, Lordship. There was a previous partition.
नहीं, आपकी बात नहीं समझ आई. Why did all the 4 brothers join in to execute the deed?
For the convenience of the procedure, Lordship. Although it was recorded in the name of Sidayal Gwala, Lordship. सील्ड का पारा 23 में रिसाइटल भी लिखा हुआ है. पारा 23 में जो नहीं सील्ड तो नहीं पारा 23 में लिखा हुआ है ट्रायल कोर्ट का जजमेंट में हिंदी में लिखा हुआ है देखा जाए. बाबाजी 73 हकीकत रहती कहानी दूसरी इंटरनल पेज नंबर 9 लोग जो हिंदी में लिखा हुआ मुझे पढ़ रहे हैं मवादी 73 डिसमिसल में हकीकत रियती कायमी जो नाम से सीदयाल गोप या ग्वाल बेरेदार मौखिर नंबर 1 भैंसुर मौखिर नंबर दर्ज पाया गया और खास में तीनों सहम दराज बजरिए बंटवारे से अलग अलग दखलकार चले आ रहे हैं। तो एग्जिबिट 2 में एडमिट भी कर रहे हैं कि पार्टीशन हो चुका है, अलग अलग रह रहे हैं।
The learned counsel has submitted that it was specifically incorporated in the recital of Exhibit 2, which was that there was a previous partition.
Lots.
However, all the four brothers had
Executed
the sale
deeds lots.
only in order to avoid further
litigation lots.
further. The learned counsel for the appellant has submitted that the recital in the sale deed Exhibit 2 with regard to previous partition has been ignored by the learned appellate court while reversing the deed. And the appellate court has primarily taken into consideration that the Exhibit 2 was executed by all the four brothers, including Shivdayal.
सीदयाल गोल
Shivdayal क्या नाम है? दयाल.
कहीं ग्वाला कहीं गोप लिखा हुआ।
Shivdayal. Considering the aforesaid submissions, he has submitted that this appeal be admitted for final hearing on account of following substantial question of law. Whether the learned appellate court was justified in reversing the judgment and decree by the learned trial court. Has erred in, has ignored the recitals in Exhibit 2 by reversing the decree passed by the learned appellate.
No.
Ye ho jayega?
जी.
This appeal is admitted for final hearing on the aforesaid substantial question. With notice be issued to the respondents under ordinary process, for which requisites be filed within a period of 2 weeks, that the records be performed from the concerned court, post this case under appropriate heading on 24th of March. ये 24th March को नहीं होगा, on 3rd of April. ये वापस कर दीजिए उनको.
Passover case from supplementary list item 2 FF 47 of 2024.
Let's take one by one. How many cases are there?
18.
Total 18. How many are listed?
17.
17. What is the 18th one?
FA 62 of 2024.
FA 62 of 24. इसका status जरा देखिए. What is the status of this case? We'll find it.
Still pending at the stage of plasma, but we have removed the defect. The only defect that is pending is the same defect that is pending in these cases, except for limitation.
Except FA 62 of 24 का status. Defectless है. तो हो गया होगा वहाँ से. आगे साल के ऐसे होगा.
it is only pending for this IA, which is filed in all these cases. We have
IA what?
ignoring the defect on the ground that we have filed one certified copy of the judgment and all batch
In all
matters.
these cases, you have filed that IA.
In these matters, we have filed, yes, we have filed IA
You have filed the certified copy in which
in
case?
2 cases. That is serial supplementary
FA number
47 of 24
47 of 24,
and 55 of 24.
55 of
24, which is supplementary serial 16.
this is serial number
First one is supplementary serial 2, second one is supplementary serial 16.
16.
16. In these 2 petition matters, we have filed certified copy of the judgment
So these 2 matters are also defective
for limitation.
for limit.
Because
Okay,
the
just a minute. Now let us see the first one, FA 47.
yes,
Correct?
this is pending for limitation. We have filed the IA.
Okay, FA number 47 of 2024. The learning council for Jharkhand has submitted that this appeal is barred by limitation by a period of 264 days. Issue notice to the
Leadership, what I was praying is, once the other IAs are allowed, which asks for filing of certified copy of the judgment, notices have to be issued in all the batch matters.
for every case notice will be. Issue notice to the respondents under ordinary process in first appeal as well as the interlocutory application. The notice should in first appeal as well as the interlocutory application seeking condemnation of delay, for which requisites be filed within a period of 15 days, 1 month, within a period of 1 month. Oppose this case under appropriate heading on April 8th, awaiting service report. Correct? Okay, next. Call for the records from the concerned court. When this order be communicated to parties. कोर्ट से आएगा रिकॉर्ड ना? कहाँ से आएगा रिकॉर्ड?
Learned tribunal.
कहाँ से आएगा रिकॉर्ड? वो 47 वाली.
Learned civil judge, special.
Okay, from the concerned court, right? चलिए next case कॉल करिए. 55 कॉल.
55.
FA 55, serial number 16.
Item 16.
In this, the matter is, the delay is for 278 days.
Period of delay कहीं भी नहीं लिखेंगे, ठीक है? It is barred by limitation. Same order करेंगे. IA number 1173 of 2025. ठीक है? इसमें भी issue notice कर दीजिए to the respondents, both in the first appeal as well as in the limitation matter, for which recusals be filed within a period of 1 month, post on 8th of April, awaiting service report. इसमें आपने सर्टिफाइड कॉपी निकाल किया कि किया?
Here,
सर्टिफाइड कॉपी रिकॉर्ड में दिख नहीं रहा।
FA 55
FA 55 होगा जरूर, नहीं तो डिफेक्टिव होता है। सेंड बैक द सर्टिफाइड कॉपी, इसमें सर्टिफाइड कॉपी जाके आ गया होगा। हैज नॉट येट बीन रिसीव्ड, नहीं आया है।
In some cases, the defects were as in
Just
the
a moment.
proper address of respondents were not, claimants were not mentioned.
In the meantime, the office is directed to send express reminder for CC of the, for sending the CC of the judgment and award of LAR case number 455 of 2012. Which was sent for necessary correction. हो गया इसका? उसके बाद नेक्स्ट बताइए।
Notice of both process.
हाँ, notice इसमें both process नहीं, सिर्फ ordinary process.
Item 3, FA 48 of 2024.
Membership in serial 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, and daily serial 11.
Next, serial number बताएंगे एक बार और, supplementary का
3 to 17
3 to 17
and serial 11 of daily list.
and 11 of daily list. आपने देख लिया 3 to 17 and serial 11 of daily list. इन सब में IA फाइल किया
IA has been filed for ignoring defect or for the fact that we filed a certified copy of judgment and we filed that in all other cases we may be exempted to file a certificate under Rule 201.
But you will be filing authentication fee. That is required to be filed. Because all the judge certified copies are filed along with authentication fee. Okay? And how will they do the staff reporting with regard to limitation? Then the limitation will be counted from the same day, from the date of judgment.
Therefore, I was praying leadership that the two copies, the two matters wherein we have filed the certified copy.
That cannot be taken for this, for the purposes of calculation of limitation. Limitation will be counted from the date of judgment. Because you are entitled to automatic deletion of that period, for which you do not get the certified copy. You do not get the certified copy. Then that benefit you will not get. The case of the date of limitation will be counted from the date of judgment.
We will file fresh limitation petitions for all these.
You are not filing any limitation petition.
No.
Then we will observe that the date of limitation will be counted without excluding that period. Can't be like this now.
We have filed the IA.
For ignoring the filing of certified copy.
The reason why limitation has not been pointed out is because we have not filed the
That's
certified
right. Once you will not file the certified copy, then under such circumstances the limitation will be counted from the date of the judgment.
That liberty that we have filed the petition for ignoring the on that point, considering that we do not have to file.
How, when you are not filing your certified copy in a case, then under such circumstances, how the period during which you have applied and you have not got the certified copy can be ignored? Can't be ignored. That is the law. Isn't it? That is the law.
That will, this will come under fresh stamp reporting after
No, we will observe it here only. No fresh stamp reporting is
the
required.
date for limitation for which we have to file.
There is
petition.
enormous delay in issuance of certified copy.
The award has been corrected. After passing of judgment, the award has been corrected by a different date.
You will have to, we do not know. The date of the judgment, etc., and then you have to explain the delay. We do not. Then that period you will not be granted the benefit.
In any case, the defect, the number of days that this FA is being delayed by, that will be pointed out through stamp reporting itself. Post.
You file the certificates. You don't bother about it. When we are simply saying stamp reporting will override our orders.
Then leadership will pass.
We explain it. Whatever it is, we do not. इसमें लिखिए फर्स्ट अपील नंबर 48 of 2024 with IA number 1180 of 2025. The learned counsel for the appellant has submitted that this utility application has been filed seeking dispensing with production of more than one copy of the judgment of the of certified copy of the judgment reviewed in the present case. He submits that this appeal arises out of common judgment, which is also subject matter of consideration in first appeal number 47 of 2024, in which the certified copy is already on record. He has further submitted that this matter has already been tagged with first appeal number 47 of 2024 and other and another cases. And therefore, the filing of certified copy be dispensed with in this particular case. Considering the submissions, IA number 1180 of 2025 is allowed, and the filing of certified copy of the impugned judgment in this case is dispensed with, subject to filing of the required authentication fee in connection with the judgment, which is directed to be filed within a period of 15 days. So far as the limitation is concerned, since the appellant is not filing the certified copy in the present case, the appellant will have to explain the delay right from the date of the judgment. Notice that you will have to file your petition for condonation of delay. कितना टाइम चाहिए?
3 weeks. 4 weeks कर दीजिए. लास्ट नंबर
Okay. Counsel for the appellant at this stage prays for time to file petition for condonation of delay. Post this case on 11th of March in the supplementary cause list. The petition for condonation of delay will be filed latest by 10th of March. सारे केस में सेम ऑर्डर करें. तो ये बैच है पूरा ब्रेक करेगा, है ना?
ये खाली लिस्टेड नहीं है वो.
हाँ हम कर देंगे. सीरियल नंबर 11 डेली कॉज लिस्ट तो अलग से ही चल रहा है, ठीक है? considering the fact that in this batch of cases, क्या होगा सिर्फ वही आएगा, बैच तो रहेगा ही. They will post it on the prefix. Yes. ठीक, हो गया सर, आइए, all आइए disposed of. You have to file your authentication.
Yes.
इसका ध्यान रखिए. This is what I am telling you. That वो जो exemption होता है for certified copy, कैसे मिलेगा? नहीं मिल सकता ना इसमें. You have to explain.
Yes.
वैसे first appeal है तो land acquisition matter है, there is nothing serious about it. But in every case, the party applies for certified copy, and then the office takes time to do the needful, and then that period is exempted by the office suo motu. Photocopy या दूसरे केस के आधार पे तो आपको exemption नहीं मिल सकता.
उसमें नहीं मिल सकता, उसमें एक्सप्लेन करना पड़ेगा कि
जो भी है, you have to give your explanation.
Yes.
उसमें जो बैच का है उसमें कॉमन ऑर्डर ही है, उसमें मिला है.
हाँ.
सेपरेट
नहीं, एक ही कॉमन ऑर्डर में सारा जितना बैच है पूरा केस नंबर करके एक एक केस का हेडिंग आईए नंबर डाल के हर एक केस का ऑर्डर. और आप ऐसा करेंगे 47 का ऑर्डर पहले बनाएंगे, 55 का ऑर्डर नेक्स्ट बनाएंगे, उसके बाद एक सैंपल जो मैंने ऑर्डर बोला है वो बना लेंगे और बाकी हम आपको एडिट करके मतलब बता देंगे कैसे बाकी का करना है, क्योंकि रिपीटिशन नहीं होना चाहिए. ठीक है.
इसमें गड़बड़ होता है, लिस्ट में फॉर ऑर्डर्स डिफेक्ट आ गया तो मैं पढ़े नहीं था, बाद में
नहीं, नोटिस है.
नोटिस है ओवरलुक कर दिया, तो उसको कल रख दीजिए, कल कर.
अच्छा, कल भी करेंगे, आज भी सुनेंगे, हम भी नहीं पढ़े हैं ना.
कुछ भी नहीं पढ़े उसको.
कोई बात नहीं. अरे भाई आपका इतना कॉम्पिटेंट जूनियर है, पता है ही विल ग्रो, आई एम टेलिंग यू. आप उनको मौका नहीं दे रहे बहस करने का. हम कल फिर रखेंगे उसको, लेकिन लेट हिम एटलीस्ट रीड द फाइल. इंटेलिजेंट लगता है हमको, अच्छा लगता है, बहुत अच्छा बहस करता है. वो कंफ्यूज हो जाता है बीच बीच में, उसको करने दीजिए. हम कल फिर रखेंगे, है ना. आप पॉइंट ऑफ लॉ अपना बेस्ट करने दीजिए. एक नया लड़का है, उसको करने दीजिए. देखिए वो ना पॉइंट पे पहुंच जाता है, लेकिन बट ही इज नॉट कॉन्फिडेंट अबाउट द पॉइंट, तो लेट हिम ग्रो इन हिज कॉन्फिडेंस आल्सो. कर लेगा, देखिएगा.
From the daily list, item 25, second appeal 218 of 2019.
Yes, बताइए. आप सीनियर हैं ऑलरेडी. हम तो आपको सीनियर समझते हैं, आप अपने आप को जूनियर समझते हैं. कितना साल हो गया? 14 ईयर्स में सीनियर नहीं हुआ अभी तक. आगे आपके सीनियर आप ही को करना है ना. ये बोलते हैं अभी ये जूनियर है, हम बोल रहे हैं अब सीनियर बन गए तो नहीं सुनना.
नहीं, अब तो सीनियर हो गए हैं, but he is not prepared.
आप सुपर सीनियर. चलिए.
This is second appeal against judgment of adjournment by defect. Suit for declaration. Plaintiff filed this suit on the basis of having purchased 2 कट्ठा 4 छठा land on 13/7/2004 from heirs of Tarun Kumar Mukherjee.
तरुण कुमार मुखर्जी.
Yes, who died on 11/4/1998, issueless, not even married. His other heir, brother or sister, someone, sold the property to plaintiff. Now, defendant is claiming on the basis of
Just a moment. From the heirs of Tarun Kumar Mukherjee, who died issueless and therefore the property reverted to the other.
no, to the other heirs,
Other
sister
heirs.
and brothers.
Sister and. they executed the sale deed.
Admitted केस नहीं है, plaintiff का केस.
Plaintiff का case है, कोई बात नहीं. They executed the sale deed on 13/7/2000
Yes.
in your favor.
No. The sale deed was executed by heirs of Tarun Kumar Mukherjee in favor of plaintiff.
Plaintiff, okay. And Tarun Kumar Mukherjee died issueless on
11/4/1998.
What is your case?
My case is that prior to his death on 10/2/1996, an agreement was executed.
Agreement of sale?
Agreement for sale was executed in favor of defendant, and he was put in possession. Part consideration amount of rupees 50,000, 75,000.
Put in physical possession also.
Pardon?
Put in physical possession also.
Yes,
Part payment of rupees
75,000.
75,000.
And the total consideration was 2 lakhs.
2 lakhs.
And since after agreement, execution of agreement, we are residing therein as prospective purchaser.
Did you file any suit for specific?
Yes, that is pending before lower court. Title suit number 302 of 2012. It is
Specific.
pending in the court of Subject Senior Division 2, Ranchi.
And who are the dependents in this case?
Defendants are agreement holders who were put in possession.
No, in this title suit. This
Title suit, the purchaser, the vendor of plaintiff.
Tarun Kumar Mukherjee has expired.
Tarun Kumar, vendor of plaintiff. They have been arraigned because they were claiming successor of Tarun Kumar Mukherjee.
Vendor of plaintiff.
Vendor of plaintiff. He was arraigned as defendant in title suit number 302 of 2002.
Who is the vendor? What is the name of vendor of plaintiff? Who is the vendor of the plaintiff?
Yes, I'm just.
Vendor of plaintiff. This agreement of sale was with Tarun Kumar Mukherjee.
No.
With the vendor of the plaintiff.
Tarun Kumar Mukherjee has executed agreement in favor of defendant.
In favor of defendant.
Yes.
Prior to his death.
Prior to his death, 1996.
1996. So the legal heirs of Tarun Kumar Mukherjee must be party in the suit for specific performance.
No, he was not made party since he had died.
That's right. So legal heirs would be the party.
Yes. That is what I am saying. Legal heir.
The same persons who have executed the sale deed dated 13/7/2004.
Yes, उनका नाम है टीके मुखर्जी.
That's right.
टीके बनर्जी. तरुण कुमार मुखर्जी that इनका
तो उसका
इनका
पीरियड
हेयर
तो
आया है.
भाई उसमें कोई टाइम पीरियड होगा ना, इतना दिन में
हाँ,
execute
3 साल के
करेंगे।
अंदर होता है, लेकिन वो
नहीं,
एग्रीमेंट
कितना है उसमें? एग्रीमेंट में कितना है? एग्रीमेंट में तो टाइम पीरियड होगा ना, कॉज ऑफ एक्शन से 3 साल होगा, दैट इज ओके।
हाँ, cause of action से।
एग्रीमेंट में तो होगा ना कि 2 महीना में करेंगे।
अगर नहीं भी होगा तो since the date of denial, तो डिनायल तो इनका है भाई, एक्सक्यूशन ऑफ सेल.
नहीं, आपका जो एग्रीमेंट है 96 का एग्रीमेंट एग्जिबिट हुआ होगा ना इसमें।
हाँ, उसमें
उसमें
तो
होगा ना कि भाई एक, अगर मान लीजिए 98 में डेथ हुआ, उसमें है कि 1 महीना में हम एग्जीक्यूट करेंगे।
देखो इकरारनामा है 10/2/96 का एग्जिबिट ए।
एग्जिबिट ए, एग्जिबिट ए का डिस्कशन इसमें कहाँ है?
एप्लेट कोर्ट का जजमेंट लिखा है। एप्लेट कोर्ट हैज dealt with from para 9 and onward. No point formulated, no consideration of order 4131.
Those points have not been formulated.
No, just take page उलट के page running page
फिर तो
17.
यही देखते हैं। This is the judgment of affirmation.
Judgment of एक आप ही के यहाँ से जजमेंट हुआ था ऑर्डर 4131 के नॉन कंप्लायंस पर।
रिवर्सल पर। वो जो वेल सेटल प्रिंसिपल्स है उसी पर है, वो कोई नया चीज नहीं बोल रहे हैं हम, लेकिन ये है कि सारे जजमेंट्स को थोड़ा एक जगह करना।
रिवर्सल था।
Was there any prayer for recovery of possession?
Yes, sir. Who got declaration and recovery of possession since we are in possession by virtue of the agreement.
The section 53 applies when the entire consideration amount is paid. Otherwise, the section 53A का application नहीं।
That is true. But after execution of the agreement, the status of the person changed if he has been put in possession.
After the execution of the agreement, if the sale deed is not executed and appropriate steps are not taken in terms of the agreement itself, then under such circumstances he does not have any right.
In the meantime, within 2 years, they executed the.
Therefore, I want to know that there is a discussion of this particular agreement of sale.
Yes.
Did it contain any stipulation? Have they discussed it? क्योंकि 2096 का एग्रीमेंट का आपने सूट फाइल किया है, सूट 2012 में
12.
सब चीज मान लेते हैं। लेट अस एज्यूम एवरीथिंग, कहाँ से होगा बताइए?
Reasoning has been given by the appellate court as well as by the trial court.
And this particular suit is of the year?
Yeah. (2007)
2007 में स्विच सूट चल रहा और उसके बाद जो है आपने जो है जब ये डिग्री हो गया
तो 12 में फाइल की,
मतलब या पेंडेंसी में फाइल की?
हाँ पेंडेंसी में फाइल की। नहीं ठीक है, एक जजमेंट केवल हमारे तरफ से कोर्ट कर दिया जाएगा, वो तो रिजल्ट तो भी जान रहे थे। एक जजमेंट उसको छोड़ दे कंडिक्टेड की जाती है। उसमें रिलेशनशिप ऑफ लैंडलॉर्ड एंड टेनेंट जो पिछली बार आप डिसाइड कर चुके।
जजमेंट आया कि नहीं आपके पास? अपलोड नहीं हो गया?
हो गया,
आई एम नॉट
हो गया। देखिए
कुछ जजमेंट्स करेक्शन के लिए पेंडिंग है ओपन कोर्ट में डिक्टेशन जजमेंट्स
देखे नहीं है, लेकिन वी एक्सपेक्ट किया गया।
असल में थोड़ा नया बोर्ड आया था, करेक्शन करने में थोड़ा टाइम लग रहा है, हो जाएगा क्योंकि बेसिक चीजें तो इंकॉर्पोरेट करनी पड़ती है ना। ऐसे
कोई मिस्टेक भी नहीं होना चाहिए,
हाँ, सब टाइम
इसलिए कि योर ऑर्डर विल बी फॉलोड इन द कोर्ट में।
हाँ, वो ध्यान देने की जरूरत है और अननेसेसरी भी नहीं होना चाहिए, जिसकी जरूरत नहीं है उसको लिखने की जरूरत नहीं है।
सेकंड अपील है
Essay number 218 of 2019. For the learned counsel appearing on behalf of the appellant, this appeal has been filed against the judgment and decree dated 14/5/2019, decree sealed and signed on 24/5/2019, passed by learned Additional Judicial Commissioner 10 Ranchi, passed in Civil Appeal number 59 of 2014, whereby the appeal has been dismissed. The trial court judgment and decree is dated 5/8/2014, within bracket decree sealed and signed on 19/8/2014, bracket was passed by Additional Munsif Roman 2 Ranchi, entitled suit number 151 of 2007, whereby the suit has been decreed on contest. The suit was filed seeking a relief of adjudication of plaintiff's right, title and interest over the suit property described in the schedule to the plaint, and for decree for recovery of possession after dispossessing the defendants therefrom. The learned counsel for the appellant has submitted that the property was belonging to Tarun Kumar Mukherjee, who expired on 11/4/1998 and was issueless. His legal heirs had executed a sale deed dated 13/7/2004 in favor of the plaintiffs. He submits that the case of the defendant was that prior to death, Tarun Kumar Mukherjee had executed an agreement of sale dated 10/2/1996 and paid an amount of ₹75,000 to Tarun Kumar Mukherjee out of the total consideration amount of ₹2 lakhs, and the defendant was put in possession of the property. The agreement of sale was exhibited as Exhibit A. The learned counsel submits that the defendants were the prospective purchaser of the property and they were already in possession of the property by virtue of the sale deed, by virtue of the agreement of sale. He has also submitted that a suit for specific performance of the contract Exhibit A within bracket dated 10/2/1996 is pending and it is numbered as title suit number 302 of 2012. The learned counsel submits that the learned courts have failed to consider that the defendant was in possession of the property by virtue of Exhibit A dated 10/2/1996, and therefore no right would have been passed on to the plaintiff by virtue of the sale deed dated 13/7/2004 executed by the legal heirs of Tarun Kumar Mukherjee, who expired on 11/4/1998. the learned counsel has submitted that, though there are concurrent findings recorded by both the courts, but this appeal is fit to be dismissed, fit to be admitted on account of improper consideration of the agreement of sale dated 10th of February 1996. After hearing the learned counsel appearing on behalf of the appellant, who has given the foundational facts as aforesaid, this court finds that the learned trial court framed the following issues for consideration. Number one, whether the suit is maintainable in the present form. Number two, whether the suit is barred by the principle of res judicata. Number three, whether the plaintiff has valid cause of action to be sued. Number four, whether the plaintiff has acquired valid right, title and interest coupled with possession over the suit land by virtue of the registered sale deed dated 13/7/2004. Number five, whether the plaintiff is entitled for the relief or reliefs as claimed for. ट्रायल कोर्ट का जजमेंट हिंदी में है, इसका एग्जैक्ट ट्रांसलेशन इश्यूज का एप्लीकेट
ट्रांसलेशन दे देंगे
नहीं है, इसका उसका ट्रांसलेशन भी है।
इंग्लिश वाला भी जो है ना वो ज़्यादा स्पेसिफिक है।
हाँ, ज़्यादा स्पेसिफिकली भी। The core issue was in connection with issue number 4, and the learned trial court considered the materials on record and recorded a finding that the defendant ये पैरा नंबर 8 को ना इंग्लिश ट्रांसलेशन में डालेंगे। ट्रायल कोर्ट का पैरा 8 इंग्लिश ट्रांसलेशन में डालेंगे, ठीक है? आपके पास है क्या इसका इंग्लिश ट्रांसलेशन? ये दे देंगे ना, और इसको जो है ना वहाँ से भेजकर जो ऑफिशियल ट्रांसलेटर है उससे कर देंगे। द लर्नड appellate court also considered the materials on record and observed that the suit was contested by the defendants primarily on two grounds. Firstly, owner of the property, late T.K. Mukherjee, entered into an agreement for sale dated 10/2/1996 with original defendant Edith John Kindo, who paid ₹75,000 out of consideration of ₹2 lakhs and put him in possession in part performance of the agreement of sale. And that he was entitled to protection in terms of section 53 A of Transfer of Property Act. The learned appellate court recorded that there can be no doubt that mere contract of sale is incapable of creating any right title in favor of transferring, and that no right or interest was created in the suit land in favor of the original defendant by virtue of the agreement of sale dated 10/2/1990. The learned appellate court also considered that the the defendant also failed to establish their title. Para 11 quote कर लिया. The learned appellate court also considered that it was not the case of the defendant that they were put in possession over the land in question in part performance of the agreement of sale of the year 1996. Rather, it was the admitted case that he and their family members were residing in some portion of the suit land and were looking after the day-to-day business of the deceased T.K. Mukherjee. It was also not the case that prior to 2004, the sole owner T.K. Mukherjee handed over the possession of the suit property to the defendants. Rather, in paragraph 16 of the written statement, it was admitted that prior to 2004, the sole owner T.K. Mukherjee went out of Ranchi due to some personal urgent work, and thereafter he never returned back in Ranchi. The learned appellate court recorded that in order to protect possession at best under section 53 capital A of Transfer of Property Act, the defendant has to establish on record that in part performance of the contract, he took possession of the property, but this was not the case of the defendant. The learned counsel for the appellant has not challenged during the course of argument any of the findings which have been recorded in paragraph 11 of the appellate court judgment with respect to the facts of the case, and as such there is no perversity in the judgment. As such, no perversity has been pointed out with respect to the appreciation of materials on the. This court finds that the learned appellate court has rightly refused to acknowledge the possession of the defendant, of the predecessor of the defendant, by virtue of.
कौन बेचा रिलेशन क्या उसे ओपन हुआ है,
अच्छा,
लेकिन उसके सिस्टर और ब्रदर बच गए थे.
By virtue of part performance of the agreement. दीजिए तो transfer property. इसमें तो फुल कंसिडरेशन का नहीं रहता, ऐसे आपको ध्यान सही
put in possession पर.
हाँ, considering the fact that the learned appellate court has recorded that the defendants were not put in possession arising out of part performance of the agreement, this court finds that no substantial question of law arises for consideration in the first place, which is accordingly dismissed.
वैसे भी concurrent finding on title and possession normally second appeal
मुश्किल है.
मुश्किल. और ये जो आप अभी पार्ट कंसिडरेशन की बात की, ये है सेक्शन 54 में, हाँ 54 में जहाँ सेल डीड का बात है, आइदर पार्टली पेड और प्रॉमिस.
तो सेल कंप्लीट लग रहा था कहीं कुछ,
हाँ सेल इसीलिए हम बोले कि सेक्शन 54 में वो पार्ट पेड और प्रॉमिस.
Item 19, second appeal 63 of 2021.
Yes, appellant. आपको इंस्ट्रक्शन मिला है
Yeah.
टीम की तरफ से?
From the court itself, and we had received the Falaknama.
Who has given you the वकालतनामा?
Issue not to defendant.
आपने फाइल करेंगे वकालतनामा?
आप फाइल कर देंगे.
कॉम्प्रोमाइज हुआ है?
No. I have no information such any compromise has been.
लॉर्डशिप को बुला देंगे लॉर्डशिप
उनको क्या बुलाना?
नहीं जो कंप्रोमाइज का जो लॉर्डशिप हमको भेजे हैं जो दिए हैं हम उनको बुलाएंगे लॉर्डशिप तो कोर्ट के सामने प्रोड्यूस करना जरूरी है जब
कॉम्प्रोमाइज हो गया है तब तो कोई एग्जीक्यूशन फाइल ही नहीं करेगा, किससे के रखेंगे क्या करें?
I have no information from the client whether any compromise he has signed.
कंप्रोमाइज के जो कॉपी भेजे थे वो कोर्ट के सामने प्रोड्यूस
ओरिजिनल प्रोड्यूस कर दीजिए।
लॉर्डशिप
किसके पास है? 2 कॉपी हुआ होगा कॉम्प्रोमाइज।
लॉर्डशिप
कुछ भी फाइल कर देते हैं
नहीं जो वहाँ से मिला है लॉर्डशिप जो बातचीत हुई बातचीत होने के बाद उन्होंने कॉपी भेजा है लॉर्डशिप उसी को हम कोर्ट के सामने
क्या लिखा है कॉम्प्रोमाइज में बताइए सर।
लॉर्डशिप की कॉपी
आपके पास नहीं है? और भी खुशी की बात। केवाला हो गया? माह फरवरी
केवाला भी नहीं हो लॉर्डशिप
उसमें इसी में लिखा हुआ कॉम्प्रोमाइज में
केवाला
माह 2 फरवरी 2025 तक कर देंगे, हो गया?
नहीं केवाला भी नहीं हो लॉर्डशिप
फिर क्या?
जो बोलते हैं कि टर्म पेंशन तहत उनको जो ट्रांसफर करना है वो पैसा वगैरह जो देना है वो सब
यह कि दोनों पक्ष द्वारा जिस तरह का मामला न्यायालय में चलाना होगा वो अपना खर्च से अपना केस केवाला के बाद उठा लेंगे। अब विड्रॉ कर लीजिए, कॉम्प्रोमाइज हो गया, यही ना लिखा है, कॉम्प्रोमाइज हो गया, केस विड्रॉ कर लीजिए। कॉम्प्रोमाइज का कहानी किया है, केस विड्रॉ कर लीजिए एज पर द कॉम्प्रोमाइज। बताइए इसी में लिखा कॉम्प्रोमाइज करा विड्रॉ करा दें, कुछ कराइए अपने नेक्स्ट डेट क्या? नेक्स्ट डेट टुमारो। ऐसे नंबर 63 और 2020। आप नाम बताएं अपना?
Satish Kumar.
Mr. Satish Kumar, advocate, submits that he has received wakalatnama from the sole respondent and he undertakes to file the same during the course. Counsel for the appellant submits that he shall seek instructions as to whether the appellant wants to pursue the present case or not. As he had submitted that the matter has already been concluded. But he wants to pursue the case or not. Post this case tomorrow at 10:30. Late आइएगा तो देर भी करना।
Item 20, second appeal 88 of 2019.
Yes, appellant.
Appearing for the respondent who is a decree holder of the partition suit. Objection was filed under order 2197/99. Same was rejected and appeal has also been dismissed. Now the question of law which has been formulated is whether the Direct Court below has committed
Order dated
13/5/19.
Yes.
Whether the Direct Court below has committed an error by not adjudicating the case on merit and in summary manner has rejected the application by the applicant. Second is whether the Direct Court below committed an error by not giving opportunity to the applicant to produce relevant documents on record.
Now the question is whether every application under 2197/99 requires to be admitted. Prima facie case has to be made out. I rely upon judgment of this honorable court.
You see, it is one thing to say that no prima facie case was made out, and therefore it is bereft of any merit completely, right? And it is another thing to say that pleader commissioner had gone there and he found that it was in possession of such and such party in the suit, and your possession was not found, and therefore there is no merit.
Now the exact case which is set up by the objector is that the property is in possession. Under what capacity is in possession? By virtue of a sale deed, by virtue of inheritance.
So therefore,
Now adverse. Now what they are pleading is adverse possession. Yes.
Whatever be their pleading, we are not here to decide whatever could be their pleading. Even for seeking a declaration of adverse possession, evidence is to be there.
Now, therefore, the ingredient has to be seen in the application under 2197 whether a case of adverse possession has been pleaded. Simply saying adverse possession, but the date on which
merely because think of a situation where a party is in possession of it, and pleader commissioner goes, he finds that some portion of the property is lost. Nobody points out that it is the key is in possession of somebody. Let us assume a hypothetical situation, and when the execution is filed, he comes and says that I am staying in this property, whatever be its capacity, a tenant, a trespasser, or permissive possession or adverse possession. Right? But his claim that he is in possession of the property, is it required to be adjudicated? Two things becomes very important. Firstly, whether the possession has been given post decree, right? And secondly, if he is claiming any nature of possession, then that nature of possession is required.
But for that matter, prima facie case has to be made out. Some document has had to be filed, some sort of possession. Merely saying I am in adverse possession. Now, ingredients of adverse possession, have they been pleaded in the petition? That has to be seen.
Whether that particular person has been put in possession of the property after the decree is something which you can certainly take a stand in the court, right? But his possession, whatever be his nature of possession, maybe permissive possession, if not adverse possession, right? Then under such circumstances, there has to be a decree to remove him from the property, even if he is in illegal possession. The government also initiates a proceeding to remove illegal encroachments.
Now,
he at best can be an encroacher over the property. How the court has entered into the arena that plead and decided the case on the basis of a pleader commissioner's report.
Pleader commissioner's report is of the year 2008.
It is not binding.
It is not. It is. But it's in 2008 there was a physical examination pursuant to which
it is not binding on you. It is not binding on you. Maybe that the pleader commissioner may have to be examined. We do not know. But it certainly requires it. It requires adjudication as to what is the nature of his possession. And just because it's a degree, you are throwing a person who is in possession of the property, irrespective of the fact as to who has put him in possession of the property, prior to decree or post decree. You can certainly cross-examine him that yes, the pleader commissioner found that you are not in possession of the property. It means that you have been inducted post decree. These things require evidence.
Can I just take let's 5 minutes? Now the case which is being pleaded is of adverse possession. Admittedly, there is no document of title. It is only on basis of adverse possession. Now, at least till 2008, he was not in possession. That is what the pleader commissioner report says. There is which is part of a decree. Until unless that decree is set aside, it is part of the decree. The pleader commissioner.
Now you tell us the pleader commissioner's report. Is it binding?
Yes, it is binding. It is part of decree. It is binding.
Show me something that it is binding.
Now, the question which has been formulated was I am just answering whether every application under 2197 or keen provision is section 47 for the party to the litigation. Now, whether every application requires to be admitted or not, that is the question which has been formulated.
No, formulated as adjudicated.
Here, whether the partition suit was instituted in the year 84. It has continued, but its final degree was passed in 2008. The respondent before lordship was a defendant, and she was allotted the portion of the property which is now subject matter of this appeal. Now let us see the objection which he has taken.
Yes. Let's have a look at the objection, prima facie.
I am reading from the appellate court judgment, it's the pleadings.
It is there. We have the text itself.
I have the memo of appeal. I don't have the objection, but again, let's see.
You have a copy of the objection?
Your Ladyship, in the impugned order itself, dated 3/12/2018, where my case has been made out, there have been specific record of statements saying that I have stated that I am on that property for the past 50 years. I am claiming through adverse possession. These are my objections, and that the fact the pleader commissioner could not have measured the property without stepping into my property.
This petition is very important.
It is there.
You jointly read it.
Yes.
Share it. Read one by one, all the paragraphs.
No.
Please read it.
Execution cases. I'll just
As reported by the learned pleader commissioner facility. Please have a look at paragraph. Here is it.
The present execution case has been filed by 11 daughter of late Radha Datta on basis of alleged allotment claimed to have been made in favor of degree of partition title suit number 1 of 84. The execution case which was instituted with respect to the alleged allotment made in favor of the state 11 covers an alleged area of 27 feet into 9 feet into 2 is equal to 48.4 square feet in possession of the petitioner as reported by the learned pleader
The
commissioner.
petitioner is Ashok Kumar.
Yes.
So he says that this particular property, as per the pleader commissioner's report, is his.
No, that is incorrect. Because the pleader commissioner had
No, I just want to know what does he want to say about it.
Your Ladyship, there are two pleader commissioner reports. One was of 2008, and subsequently after
Okay,
it was
just-
delivery,
Okay,
the second pleader commissioner report.
But he's an
That it is pertinent to mention here that the allotment chart of pleader commissioner is attached with final degree has been allegedly allotted open plot measuring 19 into 80 feet equal to 152 square feet. He submitted that the measurement submitted by learned pleader commissioner in the execution case number 20 of 16 is erroneous. The said area claimed to have been allotted in favor of degree holder is in actual possession, physical possession of the petitioner since lifetime of his father, approximately more than 50 years. The said alleged area is attached with the residential house of the petitioner over survey plot number 169 and Khata 67, Mauza Chaivasa, Nagar Palika, Ward number 7 corresponding to Chaivasa Town, Khasmal, 694, Khasmal plot 258. That while instituting the suit which has been filed 84, the petitioner and his family members were in actual physical possession of the property which has matured to title by long lapse of time and adverse possession. That while instituting the said suit, none of the plaintiffs or defendants disclosed in the plaint about the actual possession of property, and admittedly the present petitioner is not co-sharer of the partners. The plaint and the decree of the learned court clearly shows that neither petitioner nor his ancestors are parties to the decree, although the property is in possession of the petitioner has been included in the suit. The present petitioner, since lifetime of his father being in possession of the property within the notice and knowledge of the parties to the suit, including decree holder in this case, the petitioner's title to the property is fully matured and perfected by adverse possession, which cannot be effected disturbed under decree of the court, which is neither.
Everything is there, it requires adjudication. You can't go on.
But for your Lordship is aware, for pleading a case of adverse possession, some ingredients are there.
We will not examine all that.
So that once that
See,
ingredient,
he says, for last 50 years, he says that his father is in possession. He says that he within the knowledge of the parties, within the notice and knowledge of the parties. Correct? He says that the measurements is also incorrect. He also says that neither the plaintiff or neither the parties disclosed about his possession, and even the report of the pleader commissioner is incorrect.
now this for the ingredients for pleading a case of adverse possession, the date on which he came into possession,
50 years
what was
ago.
the nature of possession, whether the factum of possession was known to the other party. The question is, I'll just place a judgment of the Honorable Supreme Court. Para 25 wants to sign.
Para?
25 onwards.
Yes.
The respondent, may I just say, the respondent.
You read para 24 also.
In respect of execution of decree, section 47 contemplates adjudication of limited nature of issues relating to execution, discharge, satisfaction, and is aligned with consequent provisions of Order 21. Section 47 is intended to prevent multiplicity of suits. It simply lays down procedure and the form whereby the court reaches a decision. For applicability of the section, two essential requisites have to be kept in mind. Firstly, the question must be one arising between the parties, and secondly, this will relate to execution, discharge, satisfaction of the decree. Thus, the objective of 47 is to prevent unwanted litigation.
This is between the parties.
This is between them. Now, 25 onwards. These provisions contemplate that for execution of decrees, executing court must not go beyond decree. However, there is steady rise of proceedings akin to retrial at the time of execution, causing failure of realization of fruits of decree and relief which the party seeks from courts, despite there being decree in their favor. Experience has shown that various objections are filed before the executing court, and the decree holder is deprived of the fruits of the litigation, and the judgment debtor in abuse of process of law is allowed to benefit from the subject matter which is otherwise not entitled to. The general practice prevailing in subordinate court is that invariably in all execution applications, the court first issues show cause notice asking judgment debtor as to why the decree should not be executed as is given under Order 21/22 for certain class of cases. However, this is often misconstrued as beginning of a new trial. For example, the judgment debtor sometimes misuses the provision of Order 21(2) and 21(11) to set up oral plea, which is invariably leaves no option with the court but to record oral evidence which may be frivolous. This drags execution proceedings indefinitely. This is the antithesis of scheme of civil procedure code, which stipulates that civil suits, all questions and issues that may arise must be decided in one and the same trial. Order 1, Order 2, which relate to parties to the suits, frame of the suits, with object to avoid multiplicity of proceedings, provides for joinder of parties and joinder of cause of action so that common question of law and facts could be decided at one go. Order 1 tend to empowers court to add parties who ought to have been joined, whether as plaintiff, defendant, or whose presence before the court may be necessary in order to enable the court to effectually and completely adjudicate upon all settled questions involved in the suit. Further, Order 22, Rule 10 provides that in case of assignment, creation, or devolution of interest during pendency of the suit may, by leave of the court, be continued or by or against party or upon whom such interest has come. While CPC under Rule 30 to 36 of Order 21 provides for the execution of various decrees, modes of execution are common for all. Section 51 CPC lists the method of execution by delivery of property, by attachment and sale, by arrest and detention in civil prisons, by appointing his receiver or in any other manner as the nature of relief granted may require. Moreover, Order 40(1) contemplates the appointment of receiver by court. In appropriate cases, the receiver may be given possession, custody, and management of property immediately after decree is passed. Such expressions will assist protection and preservation of property. This procedure, within framework of CPC, can provide assistance to executing court in delivery of property in accordance with the decree. As to the decree for the delivery of any movable property, Order 21/35 provides possession thereof shall be delivered to the party to whom it has been adjourned, or to person as he may appoint or to receive delivery on his behalf, and if necessary by removing any person bound by the decree who refuses to vacate the property. As trial continues between specific parties before the court, it is based on available pleadings. Sometimes vague description of properties raises genuine and frivolous third-party issues before delivery of possession during execution. A person who is not party to the suit at times claims separate rights or interests, giving rise to the requirement of determination of new issues. While there may be genuine claims over the subject matter of property, the court also recognizes that might be frivolous or instigated claims to deprive the decree holder from availing benefits of the decree. Subrule 2 of Rule 98 of Order 21 contemplates such situation and provides for penal consequences for resistance or obstruction occasioned without any just cause by the judgment debtor or by some other person at his instigation or on his behalf, or by the transferee where such transfer was made during pendency of the suit or execution. However, such acts abuse of process of law are seldom brought to justice by sending the judgment debtor or any other person acting on his behalf to civil prison. In relation to execution of decree of possession of immovable property, it would be worthwhile to mention the twin objections which can be read. Whereas Order 2197, a decree holder can approach the court pointing out obstruction and require the court to pass an order to deal with the obstructionist for execution of a decree for delivery of possession of the property. The obstructionist can also civilly raise objection by raising new issues which take considerable time for determination. However, under Order 2199, it is slightly better position where a person other than the judgment debtor, when in dispossessed of immovable property by the decree holder for possession of such property, files an application with objection. Such objection also lead to retrial, but as the objector is already dispossessed, the execution of the decree is more probable and expeditious. Order 2197 observers come up with various objections that ideally should have been raised at the time of adjudication of suit. Such obstructions for execution could be avoided if a court pleader commissioner is appointed at proper time. Now, here in the year 2008, a pleader commissioner was appointed. The pleader commissioner did not find possession of the objectionist. Having considered the aforementioned legal complexities, large pendency of execution proceedings, and large number of instances of abuse of process of execution, we are of the opinion that to avoid controversies and multiple issues of very vexed questions emanating from rights and claims by third parties, the courts must play active role in deciding all such related issues to the subject matter during adjudication of the suit itself. Ensure that clean, unambiguous, and executable decrees passed in suit. Thereafter, the Supreme Court framed guidelines and has directed that the execution proceeding should conclude within a period of 6 months, failing which some proper reasons have to be assigned. Here is a case where a court commissioner was appointed in the year 2008, which formed part of the final decree, and the court commissioner did not find possession of the objections. So therefore the question is
who will cross-examine the court commissioner, and how without cross-examining the court commissioner, the true fact will come. Court commissioner is God.
it is not part of a decree, madam.
It is part of a decree in which the petition is not a party. The court commissioner would, you see, even the judgments are not above law, isn't it? So how can it be possible?
So my case is that the only claim of the objection is adverse possession.
Yes.
There is no pleadings do not contain the essential.
He is not supposed to file his evidence along with the.
What evidence? Pleadings. Pleadings is not sufficient. But as I'm relying in
and that is not the reason for rejection.
Reasons are not. Reasons are that.
Reason for rejection is that there was a pleader commissioner appointed.
Now, since they are pleading adverse possession, minus a kindly see. whether the essential ingredients of adverse possession have been pleaded. I am relying upon judgment of Honorable Supreme Court 2004-10 SEC 779. I'll just pass on. Para 11.
Just a moment. Just a moment. You see, what is your reply? However, it is a fact that the Pleader Commissioner and Nazir Civil Court Chaibasa has reported this learned court about alleged encroachment after due verification at spot.
After decree. This is after decree.
As required by the learned court.
This was after writ of delivery of possession was issued. After writ of delivery of possession was issued. Not before.
It is denied that the measurement submitted by the Pleader Commissioner is erroneous. Rather, the Pleader Commissioner has, after due measurement at the spot with the help of final decree, allotment chart and sketch map, has submitted his report to this.
So there are two pleader commissions. One is prior to the, well, at the time of final decree, 2008, there was no possession of the petition appellant.
I was not a party to that suit as well.
So therefore, there was a physical verification by the pleader commissioner, and there is a report. And in that report, there is no possession of the appellant. Apart from that, also, your ladyship will find there is no pleading that, or there is no document produced by the appellant that they are in actual possession. The only claim is adverse possession. So we have to see whether the claim of adverse possession as pleaded falls within the parameter as has been set by the Honorable Supreme Court. The essential ingredients are there.
I have a judgment which I
Just a minute. Yes, which paragraph of this judgment were you referring to?
2004 judgment. Pretty parallel towards the bottom portion. Plea of adverse possession is not pure question of law but granted one. Therefore, a person who claims adverse possession should show on what date he came into possession, what was the nature of his possession, whether the factum of possession was known to the other party, how long his possession has continued, and possession was open and undisturbed. A person pleading adverse possession has no equities in his favor, since he is trying to defeat the rights of the true owner. It is for him to clearly plead and establish all facts necessary to establish adverse possession. Invariable submission for your petition. From the objection application, these ingredients are not made out. And that is the only claim, adverse possession. No claim of title on basis of an instrument, entries in revenue record, record of rights.
Nothing.
This is what I-
All these ingredients are made out from the application that you had filed.
And the
Now
petition-
let us see the hearing order.
the leadership is referring to the appellate
Both the orders, because we'll see both the orders. The first, the trial court order.
attendance.
The
Yes. Attendance has been filed by both the parties through the lawyer.
Just read the finding. After hearing both sides. Read this please. This is at internal page 6, 7, continue page 7.
After hearing both
Yes.
on both the party sides, I perused the original record of execution case number 2016. It appears that decree holder has presented this execution case on 19/9/2016 on basis of final decree passed in partition suit number 1 of 84, in which so many persons have been party. The pleaded commissioner has submitted his report in title partition suit number 1 of 54, in which he has allotted share of 3 who was defendant number 10 in the suit as 561.8 square feet and open plot number 19 and open plot 19 feet into 8 feet, and this report was prepared in 20th April 2008. The pleader commissioner has not mentioned in his report the stranger to the suit as enclosed the allotted area. Decree holder has already deposited the cost of this and cost of deputation of executive magistrate to the effect the delivery of possession. This court has issued writ of delivery of possession on 19/9/2018. The Nazir and the pleader commissioner has submitted the report to this court on 3/10/2018 that one Ashok Kumar Gupta, his objector, has enclosed 27 feet length and 9 feet 2 inch breadth. This court has issued notice to Ashok Kumar Gupta 6/10/2018 to dismantle illegal construction of the suit property. The staffs Anil Kumar Mandal and Bhagwan Das have signed over the notice on 9/10/18, but Ashok Kumar Gupta has not appeared on the date fixed, that is 11/10/18. Thereafter, this court has issued writ fixing 5/12/18 for execution report. The applicant has presented this application before this court on 26/11/2018 at a later stage. The applicant has himself admitted in his petition that he has acquired title by way of adverse possession. He has not submitted any sheet of paper in respect of the suit land. The decree holder has contested the suit since 84, and when the fruit of the decree has brought up, the petitioner has filed this petition without any locus standi. The report of the pleader commissioner dated 20th April 2008 falsified the version of the objective that is in possession since 50 years. The petition filed by Ashok Kumar Gupta.
So his claim of adverse possession is primarily falsified on the basis of the pleader commission. What about the applicant? And that no sheet of paper is.
No sheet.
So, in order to, do you want to say that an adverse possession can never be established without any paper? Can it be established? Can it be established? Is there any law that for the purposes of proving adverse possession there has to be some paper? Some documentary evidence has to be there.
It is not mandatory that some document has to be there, but at least for some possession.
Therefore, the finding of the court that no sheet of paper has been produced.
Suppose if I claim adverse to the title of another, I try to get an electric connection in my name in the suit premises. I'll try to get one a municipal holding tax. I will try all these. So no prima facie there is no document. Prima facie no case is made out.
Yes, what is the finding of the applicant? In the instant case during course of execution. I think page number 11.
Petition is referred to internal page 11.
Internal page 11.
In the instant
Case.
course of The reports of execution of title partition suit number 1 of 84, either commissioner has submitted its report in title partition suit number 1 of 84, in which he has allotted a share of Prithvi Lakhan, who was defendant number 10 in the suit, as 561.8 square feet, an open plot, 19 feet in waiting, and in his report was prepared on 20th April 2008. The degree holder has already deposited the cost of resource at cost for deputation of the magician. Thereafter, the Learned Law Court had issued delivery report or delivery of possession on 19/9/2018. After issuing writ of delivery of possession, the Aziz and Pleader Commission has submitted their reports on 3/10/2018, mentioning therein that the applicant Ashok Kumar Gupta has encroached the area of 27 feet into 9.9 feet 2 inches, and on this report, the Learned Court below had issued notice to the applicant on 6/10/2018 to dismantle illegal construction of the property. The applicant himself admitted in his petition that he is required title by way of adverse possession. The applicant has also not produced any check of paper in respect to the suit that during course of proceeding or at time of pendency of proceeding. In view of the guidelines of the Honorable Appellate Court, it is crystal clear that the claim of the applicant was rejected summarily because there is nothing in the petition filed by the applicant objector before the Learned Court which suggests that which portion of the property is in possession out of the suit property and whether there is still paper to suggest how and when he came into possession of the land in question. This central principle of law, the fruit of decree cannot be denied on the strength of the so-called claim of appellate objector who subsequently came to the suit property by virtue of legal act within which it is believed that the appellate objector has perfected his title by adverse possession. In that case also it was supposed to disclose the date of possession from which the possession has become adverse to the title holder. Accordingly dismissed.
Given the area, the everything in his petition, and there is a report also that he is in possession.
But again, after the degree,
Yes, after the degree, certainly.
And the essential ingredients from which date he came into possession, from which date his
50
possession.
years he has said. Exact date may not be there.
From which?
50 years. Calculate.
Yeah, nothing more to say.
Yeah.
And another judgment which I was relying upon, whether every application or objection requires to be admitted.
What is that? You have given me 2 judgments. Rather, I would not like to give a finding that there are basic correction with adverse possession. That will not be proper also. But still, since you have advanced the argument, I have to start.
Civil court rules have been created for proper administration and smooth functioning of subordinate courts, and rules have been framed for convenient progress of trial and proceeding. Rules indicate to segregate and classify the proceedings under different heads. In that context, civil court rules indicate what type of petitions are to be registered as civil miscellaneous case for purpose of maintenance of record. In the case at hand, the petition was filed by the judgment debtor, number 1, raising grievance with the degree executed. It may cause prejudice to the judgment debtor number 2, but the judgment debtor number 2, Santosh Kumar Sharma, has not come forward with any grievance. No other point has been indicated by the petitioner which may cause prejudice to him if the degree is executed, and therefore the learned judge has rightly applied judicial mind at the very initial stage when the petition was presented before the court. Since there was no substance in the objection petition, there was no need to proceed any further. It was not needed to be registered as miscellaneous case to consume further time to decide the issue. I do not hesitate to hold that if prima facie finds if court prima facie finds no substance in the petition filed under section 47 of CBA, even after giving opportunity to the parties concerned of being heard, the court may dispose of without registering a miscellaneous. So my respected submission is, with regard to the question of law formulated, not every application under 2197 or 47 requires to be admitted.
There could be frivolous petition which can be thrown
That is what the Honorable Supreme Court
at the
says.
threshold itself.
That was the Honorable Supreme Court says that actually the litigants.
And you see, it is not your case in your rejoinder that they have been set up by the other judgment debtors.
My case
it is
that
not your case.
It is.
Rather his encroachment, it was a partition suit, right?
Yes.
His